Kia ora koutou and good morning everybody. Welcome to day 2 of the Rural Chapter hearing. Just before we kick off, there's 2 things to say by way of introduction. The first one is that there's a number of individual parties that are submitting to us today, people that probably haven't been involved in this process before, or if they have, it's been very infrequent. I just wanted to say to those people that the purpose of this hearing is for you to be able to speak freely to us about what your issues are and what you want the decision of the district plan to be. And then at the conclusion of that, if there's something that we don't quite understand, we'll ask you some questions. But they're simply to assist in our understanding of the points that you're making. So most of you, given that this is a Zoom meeting, are probably in your front room or your office or living room or somewhere else. So please try and participate in the hearing as if we were sitting around the kitchen table with you, as it were. Don't be intimidated by the process. We're not going to bite anybody's head off or ask any questions and sort of cast aspersions on anybody, irrespective of what they might be saying. So please be as relaxed as you can, and just when it's your turn to speak, just say your thing and we'll take it from there. So please try and relax as much as you possibly can. The second thing is that when you're not speaking, it's usually helpful to turn your sound and video off. You'll be able to see everything that's going on, but it just means that the bandwidth on the Zoom connection is unlikely to be challenged. Bearing in mind too that everything is recorded, both video-wise and audio-wise. Given that there are a few new faces here today, are there any questions about that? Should be hopefully fairly straightforward. Before we do kick off today, and for those people that weren't there yesterday, we've asked Council, the lawyer for the District Council, to provide her legal evaluation on the legal submissions that we'll hear later today, but which we've already read from Mr. Fuller on behalf of Middlemas and some other parties. And before we start with the submitters today, we're going to ask Ms. Parham to take us through her paper so that everybody's clear in terms of what her advice is. So over to you. Thank you, Ms. Parham. And thank you for preparing your document. It's realise we sort of threw you a bit of a hospital pass and asking you to do it at very short notice, but we're very grateful for the time you've taken to do it.
Good morning, Mr. Chairman. Yesterday I was asked to provide submissions essentially addressing 3 matters: whether the Cabra decision is binding on the panel, the facts of the Cabra decision, and the application or relevance of the Cabra decision to the Waikato context, in particular the proposed Waikato district plan. I'm just dealing with the first issue. As you're aware, Council for Middlemas Farms contends that you should place considerable weight on the Cabra decision because it is a higher order judicial body, and in fact goes further and invites you to essentially use the Cabra decision as a precedent for your decisions on the proposed plan. My submission is that that's not correct at law. The Environment Court is not bound by its own decisions. It's free to consider each case on its own facts and merits, and it follows that the Environment Court decision is not binding on the panel. In my submission, at best, the Cabra decision is a guide. Really, any 2 cases have the same factual matters arising. And I note that the Environment Court has specifically commented on whether a plan provision in one district plan creates a precedent for another district plan. And this is relevant because obviously the Cabra decision provisions will soon be incorporated into the Auckland Unitary Plan. So in the case of New Zealand Heavy Haulage and South Taranaki District Council, the court stated that they really find precedent arguments greatly convincing. Within the overall statutory structure of plan making, each situation is generally to be judged on its own merits. So what might happen elsewhere in the future will depend on the issues relevant to that particular place and time. So at paragraph 6 of my submissions, the panel's determination on the relief sought by Middlemiss Farms must be assessed on its own merits, applying the statutory tests as they relate to the hierarchy of planning documents that are applicable to the Waikato district. And I just note at paragraph 7 for completeness that I acknowledge under section 74(2)(c) that when preparing a district plan, the council must have regard to the extent to which a district plan needs to be consistent with the plans of other territorial authorities, in this case Auckland Council. However, in my submission, that obligation falls well short of the claim made by Council for Middlemiss Farms that the Cabra decision is binding on your decisions relating to transferable development rights. Turning to the factual situations arising in Cabra, I won't go through, I'll just skip through that. As you'll be aware, the decisions are quite lengthy. So the independent hearing panel made recommendations relating to subdivision rules to apply to the protection of significant ecological areas. The Auckland Council substituted its own decision for the decision of the independent hearings panel because it felt that the independent hearing panel's decision was too flexible, essentially. The Auckland Council's provisions were more constrained than the independent hearing panels, and essentially under the council's decision, the entitlement to a lot arose only in respect of significant ecological areas that were identified in a schedule, and you had to protect 5 hectares in order to get 1 lot entitlement. By contrast, under the independent hearing panel recommendations, the entitlement arose not just from ecological areas that were identified, but in respect of areas that met 1 or more of the criteria in the RPS, and the statutory threshold to get the entitlement was lower at 2 hectares, not 5 hectares. There was actually a lot of agreement between the parties in the Cabra decision, and really the outcome turned on the standard criteria for restricted discretionary activity subdivision. Significantly, all parties agreed that the transferable rural site subdivision should only enable subdivision within the country living side zone that was out of the rural area, and that was consistent with the decision of both Auckland Council and the independent hearing panel recommendation. They both provided for transferable rights only in the countryside living zone. Moving to paragraph 12, the Environment Court found that there was a clear preference in the unitary plan for transferable development rights in the countryside living zone. And at paragraph 14, the Environment Court allowed the Cabra appeals, but the Auckland Council then appealed that to the High Court. Its appeal was successful in part, so the matter was remitted back to the Environment Court. The Environment Court's decision was issued a few weeks ago. The decision helpfully attaches as Appendix C a summary of the court's conclusions on the provisions, and that was provided with a copy of my submissions. But essentially, the Environment Court concluded that the minimum lots for meeting the significant ecological area criteria for development rights should be set at 2 hectares. That was the same as what the independent hearing panel had recommended, but the court agreed with council that the right to your second lot should not kick in until you had protected 10 hectares. So that upper threshold was actually agreed by the parties. Under the IHP recommendation, the entitlement to a second lot kicked in at 5 to 9.99 hectares. So that's just a bit of a brief summary of the case without going into all the nitty-gritty details of the provisions, which I'm sure would be particularly helpful. Turning to the relevance or applicability of the Cabra decisions to the proposed Waikato District Plan, Council for Middlemouth Farms appropriately acknowledges that the Waikato District is different to the Auckland Council, and he also accepts the provisions of another jurisdiction should be carefully considered before being adopted by another council. However, despite those acknowledgements, he does urge the panel to apply the Cabra 2020 Attachment C provisions with some modifications that they've made. At paragraph 17 in my submission, there are significant differences between the Auckland Unitary Plan and the proposed plan policy framework, which in my submission means the panel should take care in transporting the Cabra decision to your decisions relating to transferable development rights. And there's essentially three main differences. The first one is, as I've already mentioned, the court expressly acknowledged that all parties agreed that the rights should only enable subdivision within the countryside living zone. By contrast, the relief sought by Middlemouth Farms on the proposed district plan does not seek to transfer the lots into a designated zone. The proposed new rules seek to transfer the lots within a 2-kilometre radius of certain roads, nearest boundaries of school sites or residential zones that are identified in a schedule attached to their planning witnesses statement, Mr. Hartley. So the location for receiver lots based on their relief is in the rural zone. So based on that relief, and this is the updated relief that is attached to the submissions of Mr. Fuller, lots as small as 4,000 square metres could land in the rural zone. That of course is below the minimum lot size in the Waikato Country Living Zone, which is 5,000, and also below the minimum size for lots in the rural zone at 8,000 square metres. So my submission, the location appears to be more, the location sought by Middlemouth Farms seems to be more flexible than the Cabra decision. Second difference is that the Environment Court accepted that the unitary plan provided a policy basis for transferable rural site subdivision, and it cited policy E15.3 subclause 4, in particular clause A, which expressly refers to using transferable rural site subdivision to protect the areas that were scheduled. It also referred to objective E39.2 subclause 12, which seeks to limit the rural subdivision to the rural countryside living zone. And the Environment Court held that the method that transfers the lot out of the general rural area was clearly supported by the general objective and policies for the rural area and biodiversity. So our proposed plan, of course, contains no objective or policy framework to enable transferable rights. And both the Auckland Council and the Independent Hearing Panel's provisions sought to encourage the transferable rights of subdivision out of the rural area. That's not the case with the submitter's relief, which applies to the rural zone. Paragraph 18, in terms of the new proposed rules requested by Middlemouth Farms, the section 32AA test, of course, is whether those rules are the most appropriate to achieve the objectives of the proposed plan, not the objectives of the Auckland Unitary Plan, which, as we know, expressly provided for transferable rights into the country living side zone. And I just, at paragraph 19, deal with the contention by Middlemas Farms legal counsel that their relief gives better effect to the Waikato Regional Policy Statement in terms of protecting and enhancing Indigenous biodiversity and ecological values. They claim the S&A provisions in the proposed plan do not go far enough to give effect to the Waikato RPS. And I just note that the S&A hearing topic has not been heard, and the Section 42A report for that topic is not yet available. My submission is that when you assess the Middlemas Farms relief for transferable development rights, you need to have regard to the recommendations that will be made in the upcoming S&A topic, as you need to look at that package as a whole. Moving to the conclusion, the Cabra decision is not binding on the panel, and in my submission does not set a precedent. The Cabra decisions cannot be transported to the Waikato context. The policy framework in the Auckland Unitary Plan expressly enabled transferable development to the countryside living zone. No framework exists in the proposed plan, and the relief sought by Middlemas Farms applies to the rural zone, not an area outside of the rural zone like in Cabra. And finally, the relief requested by Middlemas Farms must be assessed on its own merits in the context of the Waikato district and applying the documents that are applicable to the Waikato district, which includes the objective and policy framework in the proposed plan and the Waikato regional policy statement.
Thank you, Ms. Parham. Just for the benefit of submitters, that Ms. Parham's submission is on the council's website under the Hearing 18 tab, and it is under the subheading of legal submissions. So that's available if people want a written copy of it. Let's just see if the panel have any questions. Mr. Fulton?
No, I have no questions. Thank you.
Ms. Gibb?
No, thank you, Ms. Parham, for all your work.
Mr. Marg?
Yeah, again, thank you, Ms. Parham.
Mr. Cooney?
Yeah, no, thank you. Just two issues. Just the appeal, was that an appeal directly to the High Court from the council decision not to follow the independent hearing decision? So it didn't go to the Environment Court and then to an appeal. It went straight from the council's decision, did it?
No, it went to the Environment Court and then was appealed to the High Court on about 6 questions of law.
Oh, okay.
And then remitted back to the Environment Court.
Yeah, okay. The only other question is jurisdictional issue. I think I haven't checked the relief sought by Middlemas in terms of where the lots should land, but is that a jurisdictional issue that we've got here for about the particular area that's now been put forward, or does it come within the general scope of the relief sought by Middlemas? I'm sure Mr. Fuller will discuss that with us, but
yeah, I think the Section 42 rebuttal has addressed that issue. From memory, the original submission from Middlemas Farms sought transferable development rights and relied on the general provisions in the Auckland Unitary Plan, but of course those provisions relate to transferring them to the countryside living zone, whereas the relief set out in the evidence for Middlemas Farms is that 2 kilometre radius. So I guess the issue is whether that relief is a foreseeable consequence of their original submission based on the test in Albany North, or of course the was it fairly and reasonably raised in terms of the countdown test.
Yeah. Okay. No, thank you. That's helpful. Thank you.
Just one from me, Ms. Parham, and it relates to the unitary plan provisions where you said that the parties agreed and the court imposed the provisions that say the transferable development right is to be facilitated in the countryside living zone. My understanding from reading Mr. Fuller's submission is that that was a restricted discretionary activity, but that rural to rural was still provided for, but as a non-complying activity. Am I correct in that understanding?
Yes, that is my understanding.
And Mr. Fuller went on to say, and I haven't got the page reference, but I think he went on to say that, and I think it was in the Cabra decision, in fact, that a lot of those non-complying activities were granted consent under the unitary plan provisions. Do you have any comment in relation to that matter, in relation to what we're dealing with here? Because they weren't specifically provided for insofar as making them a restricted discretionary activity in the rural zone, but there was a pathway, and that pathway seems to be being used to, to a reasonable extent successfully in Auckland.
Yes, and I'm not familiar with the examples in Auckland and why it was that the council were granting a high degree of non-compliance. And I think the comments and
Okay.
the decision was that, well, that's kind of, not a reason. Yeah, so I'm not familiar with the exact.
But presumably it turns on its own set of effects and its own assessment against objectives and policies under section 104D.
That's right.
Okay, all right, thank you very much. And echoing what other panel members have said, thank you very much for preparing those for us, especially at short notice.
Thank you.
Thank you. All right, that now brings us to CDL New Zealand Ltd and Mr. Holbrook, please.
Good morning, can you hear us?
Hear you, can't see you.
Can't see us. Let's see if we can work on that. How about now?
Yes, we're good to go now, thank you. Yep, that's good.
Great, thank you. Good morning, Commissioners. So my name is Bevan Holbrook, planner with CKL, and with me on my left is Jason Adams, who is the General Manager for CDL Land New Zealand Ltd, not to be confused with CKL. And Jackson Ball is on my right, and he's a project manager for CDL. So I've got a presentation which was pre-circulated. So if I can just maybe share my screen, is that? Do you want me to do it?
Yep, that should be fine.
Yep. Hopefully this works. Can you see that?
Nearly. There we go. Yep, got it now. Thank you.
Great. Okay. So in the interest of the comments yesterday, in terms of keeping the evidence brief, we'll just run through this pretty quickly. So a little bit about CDL. They're a land-based investment company and development company, sort of doing large-scale residential subdivision work, and have done quite a bit in and around Hamilton. CDL have acquired land in the R2 growth cell, which is on the eastern side of Hamilton, between the sort of current boundary of Hamilton City and the Waikato Expressway. This area, as you'll know, is subject to the urban expansion area overlay in the proposed district plan, and CDL are looking to develop and deliver a large master plan community for this part of the world, and they're doing that by aggregating individual parcels of land and expanding their own land holding. So, like I mentioned, they currently have approximately 109 hectares in R2, and R2 has a total area of 230 hectares. So they're coming up to the sort of 50% mark. So reasons for the submission. Just bear with me, I'll just, oopsie daisy. So essentially, CDL acknowledge that there is a need to protect the urban expansion area from inappropriate interim subdivision and development. However, CDL wish to increase their land holding in order to achieve sort of scale to deliver their large scale land development that I spoke about. Now, one of the issues that CDL come across in growth cells like R2 is that landowners, existing landowners often want to remain in their existing dwelling and they are willing to sell their balanced land to them, but they wish to retain their existing dwelling and have it subdivided off. So if we look at this picture here, this sort of demonstrates a typical scenario that CDL face. So the stage one would be a first stage subdivision. You can see lot 1 contains an existing house of around 3,000 square metres. That would be ideally subdivided off, retain some form of access, obviously through a right-of-way that would be relinquished at some point in the future when it becomes developed for urban purposes. And lot 2 would be the balance area that CDL retain. Stage 2 shows how that lot could be subdivided when future zoning became possible. Obviously in the case of R2, it's expected that it'll transfer into Hamilton City and it'll be a plan change through that district. And you can see there lot 1 is subdivided around that future subdivision. And then stage 3 shows how if the house was removed at some point in the future, how it could be re-subdivided down to a finer grain again. So in terms of the relief being sought by CDL, we've made comments in relation to the subdivision rules in the urban expansion area, and we've also made comments in relation to boundary relocation rules. So the first point that CDL would like is that they'd like to make subdivision in the urban expansion area a discretionary activity, and to provide a framework to provide subdivision around existing homes, much like the example I just showed you on the previous slide. So that proposed framework is set out in the evidence and in our original submission. So essentially they will apply to titles that were issued prior to the 18th of July. So that was the date of notification for this plan. And so that is to avoid sort of ongoing opportunities for people to keep reutilising this rule. It would allow for the creation of one additional lot, but only around an existing dwelling that was established as at that plan notification date. That additional lot would be ideally between 3,000 and square metres and 1 hectare. And the reason being is to try and maximise the size of that balance lot so that that's available for future urban development. Suggested that a consent notice could go on that balance title, advising that no further dwellings could be developed on that title. And we also just make a comment there that around some sort of consequential amendments to the objectives and policies and the prohibited activity rules. That's outlined in the primary evidence, but it's mainly around that issue, which I'm sure you're well aware of, around the objectives and policies of 5.51 and policy 5.52 around avoiding versus managing that issue. In terms of the boundary relocation rule, CDL are just wanting to get a better framework to facilitate boundary relocation. So boundary relocations is another way that CDL can grow their land holding in a growth cell like R2. So boundary relocations can be used where they have an existing title next door to someone who's willing to sell, and they can essentially shrink the title around the neighbour's place, around the house, and they would acquire the balance and amalgamate it into their next door title. So boundary relocations are a very good mechanism in the urban expansion area for someone like CDL to grow their land holding So in terms of the amendments that we're seeking, we wanted the rule to refer to the creation of, or not creating additional records of title, and so not using the term allotments. Now, I believe the Section 42A report has accepted that position. This next slide sort of dives into a little bit more detail, so I don't think it's probably worth spending a whole lot of time on that slide now that the Section 42A has accepted our position, but it essentially showed the different ways that you can do boundary relocation. So the second image there shows how originally it was proposed under the proposed district plan, and then the third slide shows how by using Section 241 of the RMA you can do compulsory amalgamations. So like I said, that issue from my mind has been resolved through the recommendation in the Section 42A report, so I don't need to spend too much time on that unless you want to. And lastly, the CDL does not support the Section 42A recommendation around making boundary relocations a non-complying activity. So we would like that to retain a restricted discretionary activity to allow these interim boundary relocations to proceed and allow for CDL to keep growing their land holding through using boundary relocation provisions. So that really summarises the key points of the submission.
Thanks, Mr. Holbrook. If you wouldn't mind unsharing your screen just so we can see you more clearly, then
I'll try.
that would be helpful.
How's
there you
that?
go. Well done. Let's just see if the panel have any questions for you. Mr. Marg? What's happened to Mr. Marg? I saw him stand up a moment ago.
Apologies.
Oh, there he is. No, he's back.
Yeah. No, I had it turned off. Are you able to share the PowerPoint with us directly?
Yep.
Thank
Again, you want it back on?
Oh, no. Just to be able to send it out for us to have a record.
Yeah, it's on the website.
I didn't find it. Okay, thank you.
No, it is there. Thanks, Mr. Marg. Mr. Fulton.
Thanks, Mr. Holbrook. I take it you are talking about the this to cover all the urban expansion area, not just the R2 area that you're referring to at the moment.
That's right. The submission has covered all the urban expansion area, not specifically R2. It's just that CDL have a particular interest in R2 and that they've acquired land in that growth cell.
Thank you very much. No, that's good. Thank you.
Ms. Gibb?
No questions. Thank you, Mr. Chair.
Mr. Cooney?
Thank you for the very clear way you've presented your case, and the slides are very helpful. You're sort of in a catch-22 situation, aren't you? You got the council, Hamilton City, wanting to put a freeze on this land to enable its future urban development, and then you're a development company wanting to set up future urban developments. So, and you're caught by that situation. I just wonder, you know, how is there any tool by which you can distinguish between the ad hoc type subdivision which may occur in this area, which would compromise the future development, and also a well-planned development? I'm just wondering whether there's a method to address that situation, because at the moment what you propose is going to catch, it's going to enable a lot of others to come in under your umbrella and do an ad hoc type approach.
Yeah, absolutely, and acknowledge what you say around that ad hoc and how that can jeopardise a future urban development to proceed. And we've given that some thought, and that was why in our proposed framework we were quite clear on the fact that the subdivision could only occur around an existing lawfully established house, so you couldn't create a vacant lot. we were very comfortable with having consent notices preventing future houses being developed on the balanced land. So we were trying to think about how we could set this up so that it was being used for the genuine reason that it's intended for.
Yeah.
Interesting in terms of your comment around Hamilton City, two comments from me on that. One is in their own growth cell, down in Peacocks, for example, they allow for this type of interim subdivision to occur ahead of urban development happening. And that's been the case down there for a long, long time, where landowners have been able to subdivide off their existing house and sell the balance. Interestingly, in that district plan, it doesn't have to be around an existing house. So you could actually create a vacant title. So we're actually proposing something a little bit more tight than what Hamilton City themselves have proposed in their own district plan. My other comment just around the sort of catch-22 is just around the direction of the National Policy Statement on Urban Development, and particularly Policy 10, which requires Tier 1 councils which share jurisdiction over urban environments to work together on releasing land. And I just feel that a prohibited activity, which is what Hamilton City is seeking, is really not in the flavour of that NPS.
Okay. Thank you. That's helpful.
Thanks, Mr. Cooney. I was going to ask a similar question, but perhaps a more pointed one. And that because, I mean, on its face, it's hard to see why the sort of development that you've conceptualized in your slide is something that would find fault with the growth strategy going forward, bearing in mind that it doesn't necessarily yet exist, but it's earmarked for that purpose. Have you thought of doing a plan change for R2 all by itself and getting the support of Hamilton City for it?
Yeah, I'll probably
because that doesn't create the same set of precedents that trying to do this across all the UEA does.
Sure, I might just get Jason to comment on that.
Yeah, so CDL has been in discussions with Hamilton City for a number of years now, and we are very much working with them in that regard. Whether it be a plan change or through other mechanisms that have been promoted over the recent periods in time. There are other sort of, well, at the present time, Hamilton City Council's view is there are other matters at play, including the proposed district plan here, but equally the Hamilton to Auckland corridor, the Metro Spatial Plan and the likes, and equally, we understand that they are involved in direct discussions with Waikato District Council on how to deal with areas like R2, HT1 and 2, etc.
Okay. Okay, no, that's helpful. Thank you very much for the background.
Just on that point, isn't there some restriction on private plan changes within 2 years,
2 years.
of a new plan coming out?
Correct.
Yeah.
I was thinking in the broad about alternative mechanisms. That's all.
Yeah.
All right. Thank you, gentlemen. That's very helpful. And just echoing what Mr. Cooney said, the presentation was particularly helpful, Mr. Holbrook, because we have read the evidence. You've focused on what the problem was, and you highlighted for us what the solution you were seeking. So that's particularly helpful. And for those experts that follow, we're going to give Mr. Holbrook a 10 out of 10 for style. We'll reserve comment on content until our decision. But if others could follow suit, that would be particularly helpful. So thank you, gentlemen, and we wish you well. Which brings us to Mr. and Mrs. Chipman, please. And I think my comment at the outset about trying not to be too uncomfortable in this setting probably applied to you, I'm guessing. So I won't restate it, but I will remind you of what I said. So if you're just able to unmute your computer and turn the video on, we should be in business.
The host has stopped me.
Here we are.
Okay.
Here we go.
Good morning.
Got you loud and clear, and we can see you. Thank you.
Good. Good morning, everybody.
Good morning,
Morning.
everybody.
Morning.
Now, we're farming in Mangatangi and the northern-eastern Waikato area. And the family has been farming there 101 years. Now, unfortunately, the farm is covered the old Franklin District Council and the Waikato District Council with a paper road running through the middle of it. We have 2 titles which are on the Waikato District Council area and 1 title which was the original Franklin District Council, the paper road across the middle. All right, the 2 titles on the Waikato area are completely landlocked. There's no access to them at all by any road. Esk Road comes off Finlay Road, and then it has a private right-of-way which runs off the end of that. But our property runs along that, but we currently have no access to Esk Road. Our question is, we would like to relocate the boundary or transfer or move the titles over the paper road to what was the old Franklin District Council and put titles around the 2 houses which we have on the property. This would mean that we would have a larger land of farming, good land, and then put a title around our houses to retain, but just have a title around our house. So if I can read to you what I've written. So we wish to be able to relocate a boundary within 1 farming property, move it over the paper road. We have 3 titles adjacent to each other which cover the Waikato and previously was under the Franklin District Council. 2 titles in Waikato and 1 in Franklin, as I've said. We have had the titles in the family since 1919. Those are the Franklin ones anyway. And we'd like to move it across to... There is a paper road which runs through this property. We've gone to considerable unnecessary expense to try and relocate the extra title to the Franklin area. The council has looked unfavourably at this. The reason for the decision requested from our point of view, we will be retaining a large land holding which is more suitable for productive farming by keeping the titles in a small rural hamlet together and leaving the remaining titles in a productive farming enterprise and making the land holding larger. We feel that we have been unfairly restrained by this boundary relocation because we have been situated over 2 different councils with a paper road bisecting the property. There will be a definite advantage in keeping productive soils from being subdivided by keeping the land holding together under a boundary relocation. Now, I'm not talking specifically to all of the points, but I think that we have our surveyor who will talk to the legal side of it, but I'm just putting our personal story to it.
Okay, no, that's very helpful. Thank you. Could you, is Mr. Shuker going to, is it Mr. Shuker?
Yes, Mr. Shuker.
Is he here, is he?
No, I think he has a session later on in the morning, I think, to address all these.
Oh, okay, in his, wearing his surveying company hat, he's going to address that specific aspect. Yeah, okay.
Yeah.
Can I just ask you a question then? I just want to be clear. I'm looking at your submission, and if I can share my screen, I just want to understand exactly where you're. This is the figure. Can you see my screen?
Yes.
This is the figure that Mr. Shuker has included in his submission that he made on your behalf.
Yes.
And he said that this explains where your property is, but yes. I'm afraid I can't quite figure it out. Can you tell me where your 3 titles are on this, map?
Well, on the pink area, the one with the number NA7, well, yeah, so that is old Franklin.
But where is the, I understand that. I understand this is the paper road, but where's the, can you just explain to me where the titles that you're referring to, which is your property? Where's the boundaries?
Well, and then the other 2 titles. So our boundaries.
Where are the titles that he's referring to? I can see a whole lot of, there's a whole lot apparent, well, to my untrained eye, there's probably 10 or 15 titles.
Right, the title is that SA, that big one with the 2 with the numbers in them. Those
Yeah,
out
but
to
where's
time.
the how far do they go? Where's the boundary of them? It's not. Does it go all the way over to? Sorry. Does it go all the way over to here, or is that where's the boundary of the property? There.
Well, on the outside of where the figures are. So on the line outside where the SA 260. So you just follow the line.
Can you
so
see my cursor? Can you see my cursor?
Yes.
Is it this line?
Yes.
Or this line?
No,
or
no,
this
no.
line?
The one closest to the letters. Yes,
This
that one
line.
where your cursor
So
is.
the boundary goes all up here and round here.
Yes, it does. That's the road. And we have one dwelling there, which was our old
Okay.
existing dwelling, and we've built another one.
And
Right,
then it goes down here,
Yes, that's the other
across
one.
here, and where does it go there? Up here.
Oh, yes, up there. Sorry. Yep. All of that.
That's what I'm just trying to figure out where your
Yep.
actual blocks of
That's right.
land are.
And
No,
those
that's helpful. Thank you. I understand now. So that's fine. Let's just see if the panel's got. Let's see if the panel's got any questions for you both. Ms. Gibb.
Yes, thank you. Appreciate you coming to talk to us, Mr. and Mrs. Chipman. It's just a question about your conversations with the Waikato District Council, I presume a planner. Did they talk specifically about the paper road and whether there was an opportunity for you to purchase part of that paper road at all? Did they have any discussions about that?
Not that I know of.
No, not at all.
No, probably our surveyor has done a lot of the dealing with it, but I don't think we've been talked about with that. No.
Does that paper road actually go anywhere? Like,
No,
I know that
no.
it's only indicative, but it doesn't adjoin any other road.
No.
It joins onto the end of Miller Road,
Yes.
and it goes right across a lot of properties, and it ends up down on the corner of Finlay Road.
Okay. All right.
It's a paper road. It never will get built out.
That's what I was trying to explore, because I mean, obviously that is one avenue that you could look at, because I mean, I'm not a planner, so I don't know, but I just wonder in the meantime if it's worth actually going back and just having a further discussion with someone.
Could you send some information on that, please?
Well, I'm sure that one of the staff might pick up on that and let you know that you could have a further discussion. I don't know if paper roads were not discussed, then that could be the problem, but I don't know. I'm just suggesting. But thanks for your submission, and obviously all of this will be taken into consideration.
Thanks, Ms. Gibb. Mr. Fulton.
Yeah, no, thank you. And thank you for your presentation and the way it's been laid out. I'm a little bit surprised because I thought the boundaries between the two councils now will amalgamate. So I can't see the issue between the two, but no doubt your survey will tell us later on. So thank you very much.
Thanks, Mr. Fulton. Mr. Marg.
No questions, thank you, but thanks for the presentation.
Mr. Cooney.
No, thank you. Thank you.
I've just got one question, and it's of Ms. Overwater rather than Mr. and Mrs. Chipman. But under the proposal as it currently stands, the proposed plan as you've recommended it be drafted, my reading of Mr. and Mrs. Chipman's submission and the provisions of the proposed plan, with the possible exception of the road, which I need to get my head around, doesn't the hamlet provision sort of kick in with this particular scenario going forward?
Yeah, so through you, Mr. Chair, I've just been looking at the property on our GIS map at our end here. I think that it would, because the paper road shouldn't inhibit a rural hamlet subdivision from occurring. So looking at the configuration of the titles, I would have thought, you know, we're talking about one new rule book, whereas at the moment, obviously the current issue is possibly that there's two different frameworks in existence. So whether that's been a contributing factor to the outcomes to date, I'm not 100% sure, but I think I have actually spoken with the Chipmans previously about this dilemma. And I think that there is possibly an opportunity for the rural hamlet to provide some scope for a subdivision of some description.
That's what I understood it. That's what I understood it to be, bearing in mind that the submission that's been made on Mr. and Mrs. Chipman's behalf is really only seeking some fairly minor tweaks to what the proposed plan says in terms of a bit of detail about lot sizes, which isn't quite at the heart of the issue. I think the issue I would understand is that previously they've tried to subdivide and haven't been able to for whatever reason. And I suspect it's to do with the fact, partly to do with the fact that there's two lots of rules that apply on either side of the border, as it were, which no longer exists.
Yes.
But it's not our job to provide you advice, unfortunately. That's not our job. Our job's to hear the submissions and make decisions. But it would seem, Mr. and Mrs. Chipman, that either you or your surveyor might be advised to talk to the council staff some more, and that may shed some light on things. And I don't have any further questions. Thank you.
Thank you.
Thank you.
Thanks for your submission.
Thank you.
Which brings us to Sharp Planning Solutions. Mr. Sharp.
I'll just unmute you. Good morning, can you hear me?
Just. Can't see you though.
Okay.
So maybe if you could bring your microphone just a little bit closer.
And I'll just start the video.
Yes, please.
Start my video, okay. Can you hear me more clearly now?
Yes, we can, thank you.
Okay, thank you. I'll just grab my notes so I can read from them.
So you provided we've got a copy of your submission. You haven't filed any evidence as such. Am I right in understanding that?
Yeah, that's correct. That's more a case of time. I'm been quite busy with running my planning business.
Yeah, well, it does make it somewhat hard for us if you're going to provide a whole lot of evidence on the fly, as it were. So we would ask you, if you're appearing again, given that you are an expert in the field, we do, and our whole process relies on pre-circulation. So
I don't intend to pursue the matters further, if that helps clarify.
No, I'm just making the point that in future it would be very helpful if we received a written statement of evidence from you rather than receiving just verbal advice from you. But we'll deal with the cards that we have. So please proceed.
Okay. Thank you first of all for allowing me the opportunity to submit. I appreciate that. My main focus is the simplicity and workability of the district plan rules. We often see a lot of policies and objectives and rules that are quite open-ended and subject to speculation, which tends to waste quite a lot of time around debates. I think working with prescriptive rules from experience tends to work better, creating certainty. That's just a general overarching view. I think the Hearings Committee for resolving the indicative road rule, that was resolved, I believe, in hearing 5. So that closes that matter for me. What I've seen there is quite acceptable. The two main issues I'd like to discuss are the transferable development rights for subdivision. I've seen a fair bit of commentary around the Waikato Regional Plan Statement and a lot of commentary about how it hasn't worked in the past. I would prefer to see more commentary on how it could work. I think one of the key issues, having dealt with quite a few of these types of subdivisions in the past, is that the landing requirements for the rules were too open-ended, and it was allowing lots to land on areas that still had relatively good quality soils, and that sort of defeated the purpose of the transferable lot right. I think it could be made to work, but it would need to have a fairly clear focus on where lots would land and land in a country living zone, a designated area, or the village zone. But just adding on to my submission, I probably would like to see an opportunity for landowners who have been on land, like for example, the previous submission where the families farmed that for a century or more, where someone has been on land for a long time, that perhaps you could place one lot on the original titles as far as subdivision goes, but anything further would be within a country living zone or village zone, specific zoning for that purpose. And also I would ideally like to see, instead of having large lots of 5,000 square metres, some of the opportunities around Matangi perhaps, provided it's not encroaching on the UEA for Hamilton City Council, having smaller lots, so we can have more service lots and take up less area of rural land, and creating, for example, 1,000 square metre lot rather than 5,000 square metres. There is the Matangi community submission, I believe, earlier may have covered some of those aspects. Now that submission may have been lodged even earlier to this proposed district plan. Without recovering that, I just feel that the rural hamlet idea in principle sounds good, but it's going to create over a period of time a lot of interfaces between rural productive land and you're going to have subdivision land, which is not necessarily going to have a direct relationship with that productive land. And I can see several rural hamlet situations where you could have a situation where you've got one across one side of the road, one across the other, and you're almost sort of ending up with a mini village, which could create reverse sensitivity issues, which is really sort of starting to impinge on the rural fragmentation issues in the Waikato regional policy statement. So I'll just stop there. I think that's more or less covered my concerns there. Yeah, I know a transferable development right process isn't easy, and I believe it can be explored further. One of the other concerns I have is the dates for rural subdivision, the 6 December 1997 requirement that prevails from a previous district plan, and I do sort of have concerns about the relevance of that and whether it should be tied back into the proposed district plan date of 18 July 2018. And that's really about my summary, I believe. I don't think there's any purpose on me further covering what the members have already read. So.
All right, thank you, Mr. Sharp. Let's see if there's any questions. Mr. Marg?
No, nothing from me, thank you.
Mr. Fulton?
Thank you, Mr. Sharp. Just a comment you made regarding long-term owners or historic owners of land like the previous owners. You inferred that they could have some advantage, and couldn't that create some difficulty? I mean, your comment was inferring that they had some other rights. Am I got that correct?
Yeah, I was proposing that if someone who lived on the land for a period of time is not necessarily giving them an advantage, but they often have a direct association with that land and value being there, and it's important to their well-being, is that they may be able to have an entitlement to subdivide. Yeah, I can see that could bring up arguments if someone's, for example, if you have, say, you've been on the land 20 years and someone's been there 19 years, they could raise the argument, why can't I subdivide? I'm only 1 year off the target. Yeah, that would need to have some more thought put into it. That was referring to Mr. Mitchell's comment, a thought on the fly. I've had a few subdivisions recently where I've had people whose families have farmed the land and they've lived on the land all their lives and wanting to retire on it. It's just more of a compassionate point of view. Obviously, it would probably need to be more generic in the sense that it wouldn't only apply to retirement. You'd probably have a general rule where you can subdivide one lot, but instead of creating a rural hamlet cluster, you may create one lot on your property and the other three, for example, may be transferred off if you had an entitlement to create 4 lots, just as an example. But someone being on the land for a period of time, who has farmed that land for a long period of time, in my view, should have an entitlement to be able to subdivide, and using that as a supporting reason.
Thank you, Mr. Sharp. Thank you.
Ms. Gibb?
No questions. Thank you, Mr. Sharp.
Mr. Cooney?
No, thank you.
No, and I have no questions either. Thank you, Mr. Sharp.
Thank you.
Brings us to, I think, you, Mr. Hegley, for Fulton Hogan.
Thank you, Mr. Commissioner. I take it my evidence has been read, so I'll just address it briefly. Would that be appropriate?
Yes, please. That's exactly correct.
Okay, basically we have quarries that have already been designed to the limits in the operative district plan, which is essentially 55 decibels L10 during the daytime. The proposed plan is suggesting a level of 50 LEQ. In my evidence, you'll see I've described the difference between L10 and LEQ, and at the distances where talking about for quarries to the nearest residential property, the LEQ is in actual fact slightly more stringent than the L10. And that's due entirely to the fact that the LEQ value under the 2008 standard adopts a slightly positive metrological effect as compared with the existing standard, the original standards, the L10 works to, adopts neutral metrological effect. We'll all appreciate that if you're downwind, you hear the noise better than if there's no wind. And that's effectively what we're saying there. So that's why LEQ is slightly more stringent as a control. So that's the effect of changing for equal numbers between L10 and LEQ. Now, from the quarry's point of view, as I say, they've been designed at the 55 L10, and if the levels are suddenly dropped by 5 decibels, forgetting the fact that LEQ is slightly more stringent, that immediately puts most of the quarries into immediate non-compliance. I appreciate there are existing use rights, but that is a very risky thing to rely on long term, because you change something that may not be related at all to the noise, but the whole thing comes up for grabs again and you lose existing use, or potentially lose existing use rights. And any industry needs certainty, and any rule needs certainty as well. The whole reason the district plan has different rules in it for different things is to take into account the ability for the industry to function reasonably well, yet protect the residents. Now, at 50 decibels, that is 5 decibels more stringent than the upper limit suggested in both the standards and the World Health Organization guidelines for a reasonable level for residential accommodation. There has been a number of hearings, or 2 at least I'm aware of, in the Waikato area, and I quote those, one is Wainara and one in Nirawahia, where a level of 55 decibels from quarries has been adopted. I think the question is, do you want the quarries or not? If you want the quarries, that's fine. You should zone appropriately. And the fact that I think the Section 42A report suggested it's, or questioned whether you should have a special rule and you should go for consistency throughout. The consistency throughout is a good idea, except industries vary throughout too. So I think you need to take each industry in its own account. And the zone as a quarry or an industry, because it has more nasties, if you like, than if it's not an industry. As long as they're controlled to a reasonable level, I think that's fair enough. And that's what I'm suggesting, is that you adopt basically the position that's already there and just update to the data standards, the 2008 standards and LEQ. And in paragraph 32 on page 8 of my evidence, I set out a suggested noise control that reflects the direction the proposed plan is working to, that is adopting the 2008 standards and LAEQ. From the residents' point of view, that would give an identical or a slightly better control than they've already got at their for the quarry at the moment, the quarries around them at the moment. I have retained the notional boundary of dwellings existing at 25th of September 2004. Now, this is to stop reverse sensitivity effects, that if someone wants to come closer, we're not saying they can't come closer, but if they do, they would have to design their house to take that into account. Looking at the quarry sites, it's unlikely a house would come there, but again, quarry has to have certainty, or any industry needs certainty in the controls. So
I'll just interrupt you for a moment, Mr. Higley, and just, have you seen the rebuttal section 42A report?
Sorry, no.
Because, correct me if I'm wrong, Mr. Cleese can correct me if I'm wrong, but I think that Mr. Higley's submission point has been incorporated into your revised proposal, has it not?
Yes, that's absolutely right. So, no, just to clarify, Mr. Higley, having reviewed your evidence, and we received some sort of peer review from Thompson Taylor's acoustic engineers as well, my recommendation and my rebuttal is that we do, in fact, adopt pretty much the relief that you are seeking, with a an extractive industry specific rule at the 55 and going to an LEQ measure rather than an L10. Some of the wording is slightly different in terms of where the point of measurement is from existing activities versus new extractive activities, but fundamentally I've agreed with your relief sort.
Well, that solves the problems then, sir.
It's not that we don't like listening to you, Mr. Higley, but only to the extent that there's an unresolved issue, and I think it's been resolved. Or what I'd suggest you do is have a look at the Section 42A provisions, and if you've got any views on that, you're welcome to discuss those with Mr. Cleese offline, and he can report back to us at the when he replies at the end of the hearing.
Sounds perfect.
So I didn't want to foreclose things, but I didn't also see much benefit in continuing to discuss an issue that it seems to have been sorted out, at least as between you and the council. So let's just see if there's any questions from the panel. Mr. Cooney?
No, hello, Mr. Higley. Lucky we're on Zoom, isn't it? Because you'd be driving back. So, yeah. Thank you.
Thank you.
Mr. Marg?
No, nothing from me. Thank you, Mr. Higley.
Thank you.
Ms. Gibb?
No, nothing. Thank you, Mr. Higley.
Mr. Fulton?
No, I have nothing. Thank you.
And I've got nothing further. Thank you, Mr. Higley. Nice to see you again.
Thank you. Bye.
Which brings us to the survey company, please.
Hello, can you see me?
Yes.
Yes, I can. Thank you.
Hi, folks. Thank you very much. My name is Craig Forrester. I'm a surveyor and director of the surveying company. We're based in Pukekohe. We have planners, surveyors and civil engineers working for us. We've been operating here for 30 years across the Waikato district and South Auckland. And we have a lot of experience with the Waikato district plan in its various forms over the years. My evidence essentially seeks to introduce some additional rural subdivision rules to encourage the protection of high-class soils, which will generate a subdivision right, and the protection and environmental protection and revegetation to produce rural subdivision rights as well. Primarily, I'd like to see these subdivision rights being able to be transferred into more appropriate locations. The proposed rules only allow in situ subdivision located on the property that has the subdivision right. And very often these properties are on remote locations a long way away from essential services. I'd like to see these opportunities being able to be used in more appropriate locations. And one of these locations that we're promoting is the Buckland area, just south of Pukekohe, which is at the northern extent of the Waikato district, because it's across the boundary of Auckland Council. Auckland Council has rezoned an enormous amount of land across the road to be used for residential and business purposes. And on the proposed Waikato district plan, we're showing it all as rural land. So we're going to have cows on one side of the road and street lights on the other. In Catherine Overwater's rebuttal evidence, she indicates that the past transferable title subdivision rules have resulted in an ad hoc pattern of development. And I believe we can change this by having control over where transferable titles are able to be used. A lot of what Catherine has put in her rebuttal evidence, I totally agree with, but there are ways that we can actually fix that. We mustn't just acknowledge that transferable titles are always going to be done the same way. Auckland Council has introduced a transferable title rule, and they require all transferable titles to be sent into a countryside living zone. And they've specifically designed that zone to be where they want it to be. So I believe there's an opportunity for Waikato District Council to do the same thing. The proposed rural subdivision rules in the new plan have absolutely no control over where development can happen. They will happen on the property that has the subdivision right. So any rural character and amenity concerns will be very difficult to control. I'd like to emphasise my submission to include a revegetation and environmental protection subdivision rule by playing you some video footage. So Fraser, Fletcher, if you wouldn't mind please playing my unplanted stream video. Oh, Sandra, I beg your pardon.
Oh, yeah, I'll share that for you now.
Okay, good stuff. Thanks, Fletcher. So this video we're about to play is
Can you all
of
see
the
that?
stream.
Yes, thank you. Yeah, we got it.
Yep. This is of the Tūtaunui stream, which flows through rural countryside just south of Buckland Village. And as you can see, the land use on both sides is paying very little respect to the fact that this river is there. There's very little fencing. A lot of exotic vegetation, rural land use right up to the edge of the water. And in a few seconds, you're going to see some cows standing right up next to the water. Here we go. Okay, now we've been working on another property which is on that same river stream. It's called the Tūtaunui stream. A little further upstream from the clip that I've just played you now is a 30-hectare property on Jericho Road. And the owner of that property has carried out a lot of planting along the edge of the stream, which is being done under a rule in the Franklin section of the district plan. And that's allowed him to generate 2 lifestyle blocks on the property. So Fletcher, if you wouldn't please mind playing my newly planted stream video. This is approximately 4 hectares of planting. Has generated 2 subdivision rights on this 30-hectare property. And the owner's chosen to actually use those subdivision rights on the property. This planting is approximately 2 years old. And it's right at the very top of the Tūtaunui stream. That's the same stream we were just looking at a minute ago.
Wow.
So that planting is providing a lot of protection to the water flowing through that stream from the land use that's happening right next to it. And it would be fantastic if we could carry that all the way through to where the Tūtaunui stream enters the Waikato River, which is a few kilometres downstream. That's the top of Pukekohe Hill that you can see on the horizon in the background. Good, thank you. And I'd like to show you now a similar project, which is actually a couple of years advanced from what we've just seen. This was a subdivision that our firm has been involved with in a place called Ararimu. I'd like to show you my Appendix 4, if we can please bring that up, Fletcher. This shows a series of aerial photos of a property that's 158 hectares in size. And Fletcher, can we actually bring up my Appendix 4, not the video?
I've got that here, Mr. Bell. If you don't have it immediately to hand, I can share my screen. That'll perhaps save a bit of time. I've got it open.
Please, that'd be great.
I think that's it, isn't it?
Fantastic. Thanks very much, Phil. Yeah, so this property is 158 hectares. It's got 3 streams flowing through it. And it's made use of the exact same subdivision rule that the one we've just seen, the newly planted stream on Jericho Road, has used. Those 3 streams I've highlighted. This picture was taken back in June 2016. They look very similar to the stream, the Tūtaunui stream that we were going, the video footage we just had a look at. essentially, you know, farming right up to the edge of the stream with very little protection. So if we can just scroll forwards slowly, what I'd like you to see here is the work that these people have done on this farm.
Sorry, you want me to just flick down this like that?
Yeah, just one at a time so that you can see the change from 2016 to reach 2020. Would you mind going back to the start, please?
Sorry, I'm not sure where the start is. I just, there. Oh, I'm sorry. It's got a hair trigger on. It's got a hair trigger. That's what the problem is. Hang on.
Okay.
Is that the next one? I think it is.
That's showing you them gradually starting to work on getting some fences put up down both sides of the streams and carrying out weed eradication.
Yeah.
And then as you flick on, there you go. You can see the bush at the top left-hand corner of the picture. They've pulled down a whole lot of pine trees and they're preparing land for planting. And the next picture shows you the planting has happened. That's approximately 2 years after the planting, and that was at the start of this year.
Okay.
So that enabled them to create 8 lifestyle blocks on the property. And I've shown the position of those with the numbers at the bottom right-hand corner of the property. Now, that's an aerial photo of the planting they've done, which is sort of 4 years old. That's it. And now I'd like to play you a video of that planting. So can you please play the Ararimu video, Fletcher?
I've got that here too. Oh, you've got it there. Right, here we go.
So this is 4 years after planting down, and there were 3 streams on this property. We've just picked one of them to fly down. I just wanted to show you the result of what this particular subdivision rule of the Franklin section of the Waikato District Plan has been able to generate. It would be absolutely fantastic if we could follow through to the new proposed plan with a rule like this.
Okay.
That enables farmers across the Waikato District, who are now facing down the barrel of some very expensive fencing and planting in line with the government's Healthy Waters Act. If we can introduce a rule like this, it'll enable them to have a financial way of actually enacting it. And then following through from that, I'd really like those sorts of subdivision opportunities to be able to be used as transferable development rights, and then let those transferable development rights go into more appropriate locations closer to our villages and schools and shops and medical facilities rather than way out in the country. That's the end of my submission. Open to questions, please.
Thanks, Mr. Forrester. Let's see if there's any questions. Mr. Cooney?
Thanks, Mr. Forrester, for that. It's I'm just going to ask you what's proposed in the Waikato plan is for conservation lots, and also I think there's been an amendment proposed to allow areas to be expanded on already established. So, do you see that as a method of achieving what you've just described?
Mr. Cooney, I think that the proposed environmental protection rule is for existing bush, and I believe that they have expanded it to enable you to plant additional bush onto existing bush that already exists that meets a certain ecological standard. It goes a small way towards achieving what I'd like. The series of videos that I've showed you essentially focuses its attention mainly on streams. So rather than just picking a piece of bush on a farm somewhere, what we're trying to do is actually encourage the planting up of all of the streams through the properties to protect the waterways, and that isn't allowed for or facilitated in the proposed plan at all. Also, sorry, just to stop you there, those rules do require the subdivision rights to be used on the property that the bush is protected on, and very often those properties are a long way from essential services, schools, shops and things. So I'd like to see that ability to conserve the bush on those properties be there, but for us to be able to use that subdivision right somewhere else.
That conservation lot rule could be tweaked to allow for something like this, couldn't it?
Absolutely. I've been involved with preparing my evidence in tandem with the Middlemist submission and the Buckland Countryside Living Zone, Buckland Landowners Group, that are going to be presenting evidence later on today. So a lot of what I've got to say today is going to be reiterated in their evidence, and they have actually produced a revised set of subdivision rules that they're going to show you that include what I've just been talking about.
Which we've seen and read.
Yeah.
Yeah.
Okay. No, thanks, Mr. Foster. Thank you. That's very, very helpful what you presented.
Thanks, Mr. Cooney. Ms. Gibb?
Yes, similar comment. Thanks for showing us. It's really good to understand when you see the videos and the changes. So I appreciate your submission, and very interesting. Thank you.
Thanks.
Mr. Mark?
Yeah, no questions from me, but thank you very much.
Mr. Fulton?
Yeah, just a couple for me. Well, there's two parts. The maintenance and the protection of the stream and where the titles have been created by creating of that protection. Who then has the rights, or who has got the power to make sure that protection is maintained? Because you know, you could get a different landowner with a different view, and he might just let all the fences go. But the titles have already been taken. That's a difficulty, isn't it? A difficulty that you can have?
This kind of subdivision rule has been used by almost every council in the country for years. So I guess it's the same problem, ensuring that the landowner, whoever that happens to be in perpetuity, understands and knows that they have the requirement to protect their bush, which, you know, is through fencing and also through weed and pest control. And that is all written into the legal covenant document that gets attached to their title. So how Auckland Council is managing this now is they actually are requiring an inspection to be carried out of covenanted bush once every 3 years, and a report to be submitted to the council proving that they are actually upholding the requirements of the legal covenant. So that's something that we could possibly look at doing in the proposed Waikato district plan as well.
Okay, and I suppose my other question is just a very generic one. All the interest in the transferable titles has come directly from the former Franklin area where the titles were, and there was, looking through the submissions, there's only one other that I saw that was not from the northern region of our district. So I presume that's because of not having had them, but there doesn't seem to be a lot of interest being generated by people outside of your northern area where they have been permitted. Would that be fair comment?
Absolutely, and I guess you've hit the nail on the head. That is because it's the only place we've been able to use them. So, you know, our company has done a lot of work across the entire Waikato district, and we've got a lot of people south of the ex-Franklin border have said to us, gee, can we do those transferable titles as well? And we've had to say, unfortunately not, because you're in the Waikato portion of the Waikato district plan, not the Franklin section. So the submissions coming to try and introduce them are from those of us that have, I guess, got the experience of using them. I'd like to see them being able to be used across the whole district, because if we could, you know, go and do all of that environmental protection and revegetation planting like I've just shown you in the videos, and be able to use those subdivision rights as transferable development rights, we can try and put them into places that are more appropriate for them to go. And ultimately we'll end up with a district that's had all of its streams and rivers protected and its bush protected, and we've had some control over where we actually use those subdivision rights by writing rules to control them. Let's allow lifestyle blocks to be created in, you know, within short driving distance of schools and supermarkets, close to our main transportation routes, where it's easier for us to get around rather than a long, long way from these places.
Thank you, Mr. Forster. Thank you.
Mr. Marg?
No, nothing from me, thanks.
I've just got one. It's more a, well, it is a question. I mean, there's nothing stopping those enhancements being made by landowners voluntarily other than the cost involved. And therefore, what you're seeking is the ability to raise funds by subdivision to pay for.
Absolutely right.
That's the guts of it, isn't it?
Correct. It's very expensive to do these things, and no farmers are going to be able to afford to do them unless there is some kind of a, payoff at the end. So
okay,
if we can put an incentive,
you've answered the question. That's okay. I understand that. I just wanted to be really clear that that's the nub of the
nailed it, yeah.
Is affordability. It's not a will to do it. It's being able to fund it.
To fund it. That's right. Yeah.
Okay. Very good. Thank you. Thank you, Mr. Forrester. What's the state of? You've got 2 other statements of evidence, or your firm has.
We have. We're lined up, ready to go.
Okay. What we might do is, I think we might just. It's 10:30. We'll adjourn for 15 minutes until 11:15, and we'll hear from those 2 folks then. If I could just say, please not log off, everybody. Just mute and turn your video off if you want to do something else. We'll resume in 1/4 hour.
Thank you very much.
Thank you, everybody. Thanks, everybody. We'll resume. Thank you. Could I just say too, just before we start back on again with Ms. Wingrove and Ms. Adey, is that we do expect experts that have filed statements of evidence to provide summary statements. They're very clearly set out in our directions. We find them helpful. It's not helpful for people to be sort of ad hoc referring to bits and pieces of their evidence, and I don't mean that in a pejorative sense. So we're just stressing for all the expert witnesses that are appearing before us from now on that we do expect those to be provided, and we'll be reasonably polite about it during the course of this hearing, but perhaps less so in subsequent ones. So with that little word of caution, we'll resume with whichever of Ms. Wingrove or Ms. Adey is going to go first.
Good morning, Mr. Chair and panel. I'm Vanessa Adey, and I've written evidence on behalf of TSC in terms of the rural subdivision provisions. I'd just like to highlight some key concerns and relief sought, if that's okay, Mr. Chair.
Yep, bearing in mind that we have read your evidence, so.
Yep.
And you've heard my comments previously, but away you go.
All right. So key concern is prohibited activities. While we are opposed to prohibited activity status for PR2, 3 and 4, the activity status is extreme and should be sparingly used. Activity classed as prohibited activity means there is absolutely no chance to apply for a consent regardless of the merits of the application. A relief sought is to amend the prohibited rule status to non-comply. Timing of restoration planting for conservation lots. Requirement to plant prior to the application being lodged is extremely unfair to the applicant. The timing creates significant risks in terms of time and costs to the applicant, particularly when there is no guarantee whatsoever that the consent would be granted. My relief sought would be that Council impose standard conditions on all restoration planting subdivision consents, such as an 80% canopy closure and requirement for 5-year maintenance. Of course, there'll be conditions for completion report, and all of these conditions would have to be complied with prior to the issue of the 224C. Therefore, please delete the provision to require planting 12 months prior to an application being submitted. Terminology throughout the district plan. We have an issue with lot or allotment versus record of title. When referring to a new lot or allotment, this is not an issue. However, Ms. Overwater has recommended some changes as a result of evidence presented. However, amendments still need to be made to the general lot and conservation lot subdivision rules. Significant natural areas. I note the deletion of SNAs in full across the plan is not appropriate, as they have been identified on the planning maps. Rather, in terms of subdivision rules, it would be a benefit that they are referred to as areas of significant Indigenous biodiversity. as they have been identified and assessed by a qualified ecologist, and of course in line with the Appendix 2. We have come across an example of an identified SNA where the ecologist has not deemed it worthy of protection, however has identified another area within the property that meets the criteria. Therefore, we request that SNA be replaced with areas of significant Indigenous biodiversity. I refer to the lot size requirements embedded in policies and terminologies in policies with regards to balanced lot. Mr. Overwater and Mr. Cleese have not commented on my request to remove these numerical limits from the policies with regards to lot sizes. I continue to request to delete as it is a two-pronged and unfair approach. It also highlights conflictions with the plan, specifically general lot, boundary relocation and conservation subdivision, where these types of subdivisions do not include a balanced size requirement. Mr. Cleese, in terms of balanced lot, is open to an alternative, but refers to site, referring to a record of title. I therefore suggest land area to overcome Mr. Cleese's point. Enabling discretionary activity status. I acknowledge Ms. Overwater has amended provisions with regards to percentage of high-class soils under the general lot boundary relocation and rural hamlet and conservation subdivision provisions, and I'm genuinely supportive of the 15% concept. However, I continue to have an opinion that the discretionary activity status needs to be enabled with regard to subdivision not meeting the 20, 40 or 40 hectare minimum lot size. The general lot, rural hamlet subdivision. Consented lots and viable record of title. Also discussed in my evidence was the inclusion of consented lots and the definition of viable record of title. So we continue to request to include consented lots in boundary relocation and rural hamlet subdivision, and delete the requirement that the record of title must have a suitable building platform. Boundary relocation. We continue to request the boundary relocation to provisions to be opened up to more than 2 record of titles. There can be instances where a farmer holds multiple large titles, however wants to rearrange these to align with their current farming regime. I note that not all boundary relocations are for the purpose of creating a small lot for dwelling for rural lifestyle living. I request, therefore, that the rule include 2 or more existing record of titles. And if anyone has any questions, then please go ahead.
Thanks, Ms. Addy. Ms. Gibb, any questions?
No, thank you.
Thank you. Mr. Mai?
Nothing from me, thank you.
Mr. Fulton?
Yeah, no, thank you. No questions.
Mr. Cooney?
No, thank you. Thank you very much.
No, and I don't have any questions either. Thank you, Ms. Addy.
Okay, I'll refer you to Ms. Nick Wingrove.
Good morning, Mr. Chair and Commissioners. I'm Nicola Wingrove and have written evidence on behalf of TSC in regards to the land use. Thank you for the opportunity to participate. The key points I'd like to raise through this presentation of evidence are on worker accommodation and free-range poultry farming definition, the rule and policy framework that also crosses over to intensive farming. So I'll start with worker accommodation. With regard to the worker accommodation in the notified plan, we see worker accommodation has limited provisions and is tied to the landholder having a minor dwelling or providing alternative accommodation. However, we see worker accommodation and minor dwellings as being separate activities. So there are a number of issues with the limited accommodation provided for rural workers under the notified plan, as landholders need to provide accommodation for their rural workers in close proximity to the land that they're working. And this is clear where rural worker is responsible for animals during calving and lambing and growers at peak times, because they can both work around the clock, and these require specific accommodation on and close to the land they are working. So in Mr. Cleese's rebuttal evidence, he has bundled, or he has attempted to address providing rural and seasonal worker accommodation together with the minor dwelling by proposing to increase the size of the minor dwelling from 70 square metres to 120 square metres with perhaps a dormitory fixture to provide accommodation if the minor dwelling is tenanted, to then provide it to rural workers or seasonal workers. But there's two issues with that. So like in terms of size, we note that 120 square metre minor dwelling from 70 square metres is a significantly sized minor dwelling. But really the suggestion 120 square metre sized minor dwelling can be used for both isn't feasible, because in some cases workers reside with their family, which then under this proposal the tenants would be asked to share that space with their family during peak seasonal periods. So I just don't see how that might work. And I understand Mr. Cleese's concerns around the density of dwellings, and the intention of the plan provision is to avoid establishing dwellings that may then be sought to be subdivided, but this is managed by being prohibited in the operative Franklin District Plan Subsidiary Dwelling Rule 23A 4.25. So the relief sought for worker accommodation is to bring through the operative Waikato Franklin District Plan Rule 23A or similar for, that Rule 23A 4.25 to provide specific worker accommodation as a restricted discretionary activity rather than worker accommodation being non-compliant. The second key point is around free-range poultry farming. So we sought relief to provide a definition and amend the activity and status for free-range poultry farming to simply be specified as a permitted activity under farming, and the amend the Rule 2213D to be consistent with the definition sought. Mr. Cleese has proposed to mirror image the definition of free-range poultry farming to when it is extensive or intensive farming, but in my opinion, it would be far simpler and clearer to roll over the operative Franklin District Plan definition for free-range poultry farming and remove it from intensive farming, because I think Mr. Cleese's opening statement, he agrees that free-range poultry isn't intensive farming. So, so we seek relief to remove the free-range poultry farming point 4 from the notified plan intensive farming definition. And so really the definitive wording within both the permitted farming activity status and the activity specific conditions is clear enough guidance of this activity and rules. And lastly, so should relief of our final recommendation for a new definition for free range farming not be accepted, we seek to reinstate the deleted notified rule 2213D and E, the land use activity rule, as originally notified. The relief sought. Any questions?
Thanks, Ms. Wingrove. Mr. Kearney, any questions?
No, thank you very much.
Thank you.
Mr. Fulton.
Yes, just a question on workers' accommodation and how that's defined, because I mean, it's an easy way to say worker accommodation, but then I think what is being looked at here is a lot of seasonal work as opposed to a permanent staff member. Is that right? You know, you can have worker accommodation for horticulture, for instance, which is going to be seasonal, or you're going to have a permanent staff employed on a dairy farm, for instance, is worker accommodation. Can you just make those distinctions between what you're really referring to here for either short-term or seasonal?
I understand that rural worker accommodation could be provided long-term and short-term. So a dairy farmer would need a worker accommodation long-term for his dairy worker and accommodation. You know, and with the minor dwelling, if he had a minor dwelling, yes, that rural worker could reside in that minor dwelling, but he may also want to tenant that minor dwelling and provide worker accommodation, which is provided for in the Auckland plan.
Okay. I think we ran into this once before, one of our other hearings about accommodation being provided, and I just wanted to be clear about what we were trying to do here. Okay, thank you.
Mr. Mark?
Nothing from me, thank you.
That's good.
No, nothing. Except I do see the difference between temporary, fruit picker type accommodation to permanent farm accommodation, and I imagine those fruit pickers don't have their families with them, and it would be more of a hostile, not hostile, hostile accommodation situation
for the temporary pickers and growers.
Yes.
Yeah.
So I think there does need to be some distinction in our minds as to how the wording reflects both. So thank you.
And I have no questions. Thank you, Ms. Wingrove.
Thank you.
Thank you for you and your colleagues for your evidence. Which brings us to Federated Farmers, please. Ms. Walker.
So good morning. Just been taken off video, sorry, but that's okay. I can handle that. I can go for a minute, sorry.
I think you might have done that to yourself.
Oh, there we go. So you can hear me okay, can't you?
Yes, thank you.
Yes, so good morning, Chair and Commissioners. My name is Hilary Walker. I'm a Regional Policy Advisor with Federated Farmers. And with me today virtually is Stephen Stark. He's our Chair of the North Waikato branch. Stephen's on his farm, so he will come in. He's online, I can see, but may not necessarily need to speak unless you may have some questions directly. I do need to give apologies for Bruce Cameron, who is our Franklin Chair. He's unable to make it today. So we appreciate the direction of the Chair to focus on outstanding matters of contention. Oh, there you go. Thanks, Stephen.
Yeah, I'm on. I haven't got video though, have I?
Should have. Well, it's up to you.
Yeah, I'm just trying to figure out why it's not going.
Let's go. I can keep going if you like, and you can work through that.
Yeah, bear in mind that you've got a 10-minute allocation for a summary that we didn't get pre-circulated. So
the summary was provided, but
if that's the case, I apologise.
Yeah, but that's okay. Yeah, so yes, definitely was provided within time.
Okay, thank you.
So the outline, so as outlined in our summary, we are strongly supportive of the implementation methods which have landed with regards to the day-to-day activities of farm or day-to-day farming activities, with the exception potentially of changes which have been made to the definition of farming noise. The remaining issues for us relate to recommendations as they apply to activities which can be categorised as non-farming activities, the definition of intensive farming, the general subdivision rules and TDRs. So turning first to non-farming activities. The primary concern, which relates to the way non-farming activities have been prioritised through the recommendations, relates to reverse sensitivity effects, which can be created when new sensitive activities set up in close proximity to farming properties. We certainly understand the importance of vibrant and thriving rural communities and recognise that there are a range of non-farming activities that are important contributors to the social and economic fabric of a rural community. But these are usually of a scale and intensity that will not cause more than minor effects and will not work with, not against, the usual and expected farming activities. Examples of these include sports clubs, home-based accommodation or childcare businesses, local halls and churches. The reporting officer has taken these concerns on board. However, some of the recommendations will have the perverse outcome of relegating the importance of primary productive activities within the rural zone and elevate activities such as education facilities and non-farming related businesses inappropriately. Recommended changes provide the same consenting pathway for activities that are not reliant on the rural zone and at a scale of and intensity that have potential to significantly increase reverse sensitivity effects on those that are. It is the sensitive nature of the activities and the scale of them which generates concern and creates the expectation that new schools and new childcare facilities should be required to go through a discretionary resource consent process. The same concern applies to wedding venues, which have been used as an example of a rural commercial activity. Wedding venues do not have a functional or operational need to locate in the rural zone and do not service rural activities. Wedding venues are not rural-related, non-farming activities, and as such should not be afforded equal priority with the activities that are. Wedding venues do locate in the rural zone and can contribute towards amenity value. However, we know of examples where conflict has been created between the very different activities and expectations of those running a wedding venue versus those running a rural contractors depot next door. Our position asks for a cascading rules framework which implements the recommended policy direction, and particularly in relation to a rewritten policy 5.3.5, and ask that wedding venues, childcare and schools which do not rely on rural land or the soil resource and do not have a functional or operational need to locate in the rural zone, the same consent activity status as intensive farming, rural industry and rural commercial which do. In our view, that does not provide a clear direction to plan users as to what are normal and expected activities within the rural zone, and does not implement the intentions expressed in the objectives and policies of the chapter. Moving to the intensive farming definition. So we raised concerns through the submission process that the proposed definition could have potential to extend the meaning of intensive farming beyond usual definitions and capture extensive activities. From our perspective, with the exception of one issue, we are relatively comfortable with the Section 42A report recommendations. The remaining issue relates to the exclusions to the definition. And whilst we support the purpose of the exclusion and the recommended additions, which will include as exclusions feed pads and standoff pads ancillary to pasture-related farming and horse stables, we are concerned that the purpose of the exclusion at C, which relates to indoor rearing or weaning of livestock, is not clear and has the potential to create uncertainty as to what rearing or weaning activities are excluded and what are included within the intensive farming definition. It is understood from the Section 40A 2A reasoning that the intention of Clause C is to distinguish between facilities that have a specific focus on rearing and are therefore more likely to be intensively used throughout the year, compared with facilities that are simply used for on-farm stock replacement that is ancillary to a pasture-based system and are therefore less intensive in nature. The report writer questions whether the limitation would be better focused on the length of time the facility is used rather than the number of stock and purpose behind the rearing, and asks for submitters to provide comment on this. Raising and weaning young stock is a usual and expected activity within the rural zone. It is appropriate for a district plan to enable this activity. We would be more supportive of a length of time the indoor facility is being used as a proxy for intensity, rather than arbitrary numbers of stock. It is the frequency of the activity which creates the potential for unreasonable adverse effects that may need to be managed. We advise against applying a specific seasonal period to recognise that different farming systems can raise and wean young stock at different times across the year. Dairy farmers supplying winter milk, for example, will be calving through March through May, not July through September. From our perspective, limiting the activity to stock numbers is a blunt and arbitrary proxy for intensity, having the potential to capture rearing and weaning stock which will remain on farm to either replace breeding stock or provide store stock to be on-sold. Either activity is ancillary to a pasture-based system and therefore not intensive in nature. There is concern that the reared as replacement breeding stock to be used on the same property exception to the stock numbers in Clause C could be interpreted as being an activity not excluded from the definition, thereby being captured by the intensive farming definition inadvertently. The different exclusions provided for under C should be decoupled to avoid this potential interpretation issue and provide certainty to plan users. So moving on to general subdivision. Fair and Farmers' general position with regards to subdivision is on protection of productive land to ensure primary production can continue to ensure the long-term viability of the agricultural sector. However, this general position is balanced against the fact that land needs people, its growers and farmers, to make the land productive. Farming is often a multi-generational enterprise, with the land asset providing a place for both home and farming, home and farm. This means farmers value flexible policy settings which enable farm succession planning to occur, provides for practical boundary relocation outcomes, options, and incentivises win-win opportunities to create good public good environmental outcomes, whilst at the same time understanding the issues created by fragmentation of productive land. As an organisation, we believe that council subdivision and development policies and planning should provide for managed growth within the rural communities. Whilst it is acknowledged that the loss of productive land can impact on a district's economy, there is also a need to recognise that farmers undertake small lot subdivision for a range of reasons, including farm succession and to dispose of surplus dwellings. The Federated Farmers' submission on the notified plan was broadly supportive of the approach being taken, in particular with regards to the 20-hectare minimum parent lot size, enabling property readjustments, clustering, the prioritising of cluster and homelet development, and providing incentivisation to create win-win environmental outcomes. The recommendations, which will double the minimum lot size for eligibility of subdivision, has been opposed by a number of parties, including Federated Farmers. This is a significant departure from the notified provisions, and one that only submitters well versed in planning processes will have picked up. Using rebuttal evidence, Ms. Overwater disputes that landowners will be surprised by the recommendation because the 40-hectare lot size has been the goal of the Regional Council since Plan Change 2. Ms. Overwater advises that this future direction was signalled during the appeals process of that plan change. We suggest that landowners will have looked to the notified plan to determine what the minimum lot sizes were proposed to be and assess their interest against that, not an appeals process which they will not have been a party to. The notified provision has retained Plan Change 2 resolution of 20 hectares. The review of the full plan provided an opportunity to reconsider the lot sizes and determine whether any changes were required. In our view, the notified version should be adopted. If the submission process has identified a significant resource management issue for the Council, it can be addressed through plan changes which are likely to be required to implement national policy statements, and this will include a national policy statement for highly productive land. So with regards to transferable development rights, we have not put up any planning evidence with regards to this matter. However, I have been asked to make the panel aware that members are frustrated at the all or nothing approach which Council has adopted. It appears the problem child has been thrown out with the bathwater rather than Council trying to figure out how to get the best out of the child. We accept there has been issues with ad hoc development taking place under the Franklin system and that it is not an easy process to facilitate. However, the opportunities to provide really useful win-win outcomes for landowners, future landowners and conservation outcomes is worth the effort. The issue of TDRs and opportunities to provide useful incentives to landowners has been contemplated by central government during the consultation on the draft National Policy Statement for Indigenous Biodiversity, with a specific question being asked as to whether the NPS should include a provision on the use of transferable development rights. Federated Farmers responded positively to that question, advising that consideration of how tax incentives or transferable development rights could be provided to encourage and remove barriers to expenses associated with private biodiversity outcomes would be supported. And then just to note, with regards to some of the discussion yesterday, particularly around Objective 5.1.1 and policies which were trying to establish the description of the zone and rural character, we suggest that the recommended wording that Ms Wolf has put up for Horton Z, particularly in relation to that policy, that Objective 5.1.1 and Policy 5.3.2, do strike the right balance, and we would lend our weight, or we have lent our weight to that relief sought. So that ends my sort of formal piece. So we're open to questions or anything Steve would like to add.
Yeah, Hillary done a good job of the submission. Really, I'm just here to take questions if you have any questions of me, but obviously I support Hillary.
All right, thank you. No, that's fine, thank you. All right, let's see how we go with questions. Let's start with you this time, Ms Gibb.
No, Mr Chair, I do not have any questions, thank you.
Thank you. Mr Fulton?
Just one, yeah, well, perhaps a question. Ms Walker, the experience that I would have picked up is that the majority of people do not look and go through provisions that would have been set out in the plan. I think they rely pretty much on the likes of Federated Farmers and others to pick up on it. And you inferred that farmers would have been going and looking online at the district plan. Would that not be fair that they expect people like you to pick up on these things rather than, I couldn't imagine many farmers sitting down and ploughing through a district plan.
No, so that is an absolutely fair point. It's particularly when it comes to land use activities that will affect their farming businesses, that is absolutely front and centre of what we do and why you would be a member. When it comes to subdivision rights, that's a slightly different matter. As you would expect, farmers there's quite a differing perspective and view across the farming community around subdivision rights and potential with that. We often maintain a fairly neutral position when it comes to that because it can be difficult to get a clear mandate from the membership around subdivision rights in particular. So I wouldn't say that we necessarily hold, and we certainly don't represent all of the rural community as much as we'd like to. So you couldn't necessarily rely on a Federated Farmers position or point when it comes to, or use it as the proxy for what the rural community thinks on a subdivision, say minimum lot size, for example. So we do urge members to look directly to, to online, and many are very familiar with negotiating websites these days, and remind them that their own interests with regards to subdivision rights may need to be addressed individually. But that said, we have got a stake in the ground in terms of process, I guess, and making sure that good, robust process does take place with these matters.
Thank you, Mr. Walker. Thank you.
Mr. Marg.
Nothing from me, thank you.
Mr. Cooney.
No, thank you.
No, and I don't have anything either. Thank you, Ms. Walker and colleagues. That's very clear. Thanks.
Thank you. Appreciate that.
Now we've got Madsen Laurie surveyors. Mr. Laurie, I think, is there. You there, Mr. Laurie? Are you there, Mr. Laurie?
Almost, Mr. Chairman.
Here we go.
Oh. Thank you, and sorry for that. Technology's not my strong point, and I've also heard your warnings to other experts about pre-prepared material.
Yeah, that was a general comment earlier. So that was a general comment earlier, and I don't mean any disrespect.
No, that's right.
But we would appreciate it going forward, please.
Yep. No. Well, I don't have any firm evidence to provide. I was really here to answer any questions over our submissions that we've made, but a couple of points. And I've just heard the evidence from the surveying company about prohibited rule, and that was one of our key submissions that we believe that whole section should be deleted, and we believe shuts doors that could be better utilized. And the title date of December 6, 1997, if you hold that rule, we believe that needs to be taken out. Most of our work is around the old Franklin district, and obviously the properties up this way have not had the opportunity for a general purpose lot, and therefore jumping or excluding those is unreasonable. Under the general subdivision rule 22.4.1.2, we believe that you should stick to the 20 hectares, particularly up in the Franklin area, because again, they haven't had that advantage that the Waikato brethren have had. There wouldn't be a lot of properties affected anyway, so it's not going to create mayhem. The other aspect size to be 8,000 square metres. We think that should be reduced. We note that regional council normally require a minimum of 2.5, and we believe that if you're creating a small lot, 8,000 is wasting land and creating fragmentation unnecessarily. And a similar provision in Rule 22.4.1.4 under boundary adjustment. There's arbitrary limits on section sizes there. In the past or recent past, there have been lots created less than 5,000, which we believe should be eligible for boundary adjustments, particularly upwards. And similarly, if you're adjusting boundaries of larger lots, we believe you should have the opportunity to come below 5,000. With conservation lots, we think that the current rule as modified is while it's setting out to protect versatile land, we think that the artificial barriers that are being introduced could prohibit people with suitable bush areas to not proceed if they can't create a lot because they can't comply with the 15% maximum. So that's all the statements I would make, but happy to answer any questions over any aspects.
Thank you, Mr. Murray. Let's see if there are any questions. Mr. Fulton?
Yeah, thank you, Mr. Laurie. You just made a reference to and saying that you thought that some of the area should be left. You inferred that there's a one district plan, and that's what we're charged with, is putting one district plan for the whole of Waikato region, or the council. And you were inferring that you could have the northern area being slightly different in its rules. Do you think that's a fair comment? I mean, we're charged with one plan for the whole of the Waikato district. You can't have divisions,
no,
can you?
Well, preferably not, because it makes it awkward for us as well. But no, that's not what I was really inferring. I was inferring that including the Franklin provisions to match Waikato is unreasonable. I think it should be the other way around. Bring Waikato in terms of some of the Franklin provisions.
Okay, thank you, Mr. Laurie.
Ms. Gibb?
Yes, I had a similar thought about that, and I can see your point, but it's just a matter of how we deal with it. That is the issue. So I guess thank you for your submission, and you'll need to leave us to contemplate that. Thank you.
Thank you, Ms. Gibb. Mr. Marg?
No, nothing from me, Mr. Laurie. Thank you.
Mr. Cooney?
No, thank you, Mr. Laurie. Thank you.
No, and I have nothing. That's, I think what you're seeking is clear, so I have no questions. Thank you.
Thank you, Mr. Chairman.
Thank you. Is Ms. Gore with us, or Mr. Gore? I don't see them there, but... Oh, yes, there they are. Would you mind just saying something, just so I can now see you? Just want. Yeah, no, we can hear you. That's good. Thank you. Just when you're ready, thanks.
Okay, good morning. Andrew is with me this morning.
Morning.
I'd just like to speak toward my conclusion in my submission of evidence. And we have some outstanding points in relation to the submission. The first one is there are conflicting requirements of multiple overlays in the rural zone affecting our property. Number two, the proposed policies, objectives and rules are unfairly penalising us for our land use. An example of this is the proposal by the Hamilton City Council to hold our land for urbanisation for maybe up to 30 years. Number three, there appears to be little consideration in the proposal for the Waikato ecological basin in the area where we reside in particular. And we did draw attention to that over the comments that were made by Overwater and Cleese in relation to holding the land and not using it, and for what could be up to a 30-year period. And number four, not everybody desires to live in high density housing close to a city. And there are examples which we did provide in our appendices around that. And there are further examples in West Auckland around eco housing close. So the relief that we seek is the removal of prohibited status from our land, including a ruling that would see it being held doing nothing, which we don't feel is an acceptable outcome. And number two, to allow a conservation lot development to meet some immediate housing need. Our preference would be not to develop into the rural block, but in light of the pressing need for housing, we would find that acceptable to do a conservation type development that would also provide a more ecological answer by managing the environment for the benefit of everybody over the next term in a more shorter term idea, like in a 10-year plan rather than holding an empty space for 30 and then possibly creating other ecological problems that we have alluded to in our submission. And number three, we support the Council's recommended approach of removing prohibitive status from non-rural development for veterinarian clinics. In Cleese's summation, he has supported that, but he has said that for us, that is prohibited. As this is our livelihood and our line of work, and we have the land where we would like to do that, we would like the prohibited status to be lifted so that we can develop under the rules that are being proposed. So that is basically the conclusion of our submission.
Thank you, Ms. Gore. That's pretty clear. Let's see if there's any questions for you. Let's start with you this time, Mr. Marg.
No, nothing from me. Thank you, Mr. and Mrs. Gore.
Mr. Fulton.
Yes, thank you, Mrs. Gore. So it's really the urban expansion area that's over your property that seems to be your biggest stumbling block, isn't it?
Mm.
Yes, it places us in a number of zones as is outlined in our conclusion. We're under the rural zoning and we're under the urban expansion area zone. We're in the Hamilton ecological basin area, but we're also fragmented by what has happened around our land. So it's placed us in four sort of separate things and none of which work together.
Okay, I understand that. Thank you.
Ms. Gibb?
Yes, thank you. Thank you, Mr. and Mrs. Gore. So as well as that, I'm just trying to picture it. I think you've also got the Waikato Expressway nearby, is that correct?
Yes, and Resolution Drive runs up one of our boundaries.
Yes, which is proceeding in its formation, isn't it?
Yes.
So, yeah. Yeah. Okay. Yes, I can see the dilemma. So yeah, thanks for that. I just wanted to get more of an explanation around where you were, and it is like a perfect storm, I presume.
Yes.
Thank you.
Mr.
Not
Cooney.
so perfect. Not so
sorry,
perfect.
sorry, Ms. Gibb.
I just was saying not so perfect. Yeah.
Mr. Cooney.
No, thanks for the concise way you've summed things up. Thank you.
I've got a question, but I think it's probably more directed to Mr. Cleese and or Ms. Overwater. And the Section 42A reports effectively talk about not precedent, but have sort of taken a one-size-fits-all approach to all the properties that are in either the overlays or the zonings that Mr. and Mrs. Gore refer to. My question for either or both of you is whether you think there is anything that distinguishes this property from others that are broadly in the same zones and or overlays that might make it appropriate to take a special approach, if you like, for this particular block of land, as opposed to the blanket approach that's been taken. Do you have any comments, either of you, on that?
Maybe if I go first. I'm not convinced that it's significantly different enough from other blocks within the UAE. So obviously within the urban expansion area of Hamilton, there's a range of properties, a range of different sort of sizes and uses at the moment. I'd be quite cautious about coming up with a very different approach to, say, subdivision, just for the Gores property, and how you might differentiate one specific site from the UEA in general. I would just like just to clarify for the Gores, with veterinary practices, which you mentioned. My recommendation would actually be that it's non-compliant rather than prohibited. So within the UEA, so I think it was prohibited under the proposed plan as notified, but I also said that there should be a consenting pathway available there. So just to clarify that for you.
Thanks, Mr. Cleese. Is there anything you want to add to that, Ms. Overwater?
Yes, Mr. Chair. So I was just having a quick look at the conservation lot rule, because that kind of stuck out in my mind as Mr. and Mrs. Gore were talking to subdivision opportunities. So what I've just picked up on is that while we've got a non-complying activity status for subdivision for additional lots in terms of a general subdivision or a boundary relocation or a rural hamlet, there is no restriction in regards to the conservation lot subdivision rule within the urban expansion area. So if that was something that they were wishing to explore in terms of what is on their property, I would see no differentiation between any other landowner in that area. So I think that there could be potential there, but again, that depends on what they put forward. So yeah, that would be my only comment in respect to what I've just observed there in terms of the presentation and your question.
Okay, thank you. No, that's helpful. Thank you both. I don't have any further questions of either of you, Mr. and Mrs. Gore, but thank you for your submission and the way you've presented it.
Thank you.
Thank you. Which brings us to the Tamahere Eventide Home Trust, Ms. Feathers.
Hello, can you hear me?
Barely. Could you just sit a little bit closer or move your microphone in, or both?
Better?
That's better, thank you.
Okay, thank you. So Louise Feathers, I prepared statement of evidence for the Tamahere Eventide Home Trust. Zooming in should be Louis Fick, who is the CEO of the Tamahere Eventide Home Trust. So if there are any questions specific to the activity, then feel free to ask. Now, I haven't provided a summary statement because my evidence is so brief. Basically, all we really want to say is that we are in support of the council approach. to the retirement village provisions. I have put in my evidence a few minor changes that we'd like to see, and that really relates to existing or consented retirement villages being permitted as a starting point. But really, that is it.
I think that's been, I might be wrong, but I think that's been incorporated into the rebuttal version of the provisions that staff have recommended, is it not?
Excellent.
I think that, could someone either confirm or put me in my place on that?
No, you're quite right. I was happy to recommend that change in rebuttal.
Yeah, that's what I thought. So it looks like, as far as the staff are concerned anyway, Ms. Feathers, that that matter's been resolved.
No, that's fine. So really just to say that we're in support, which you're probably not getting much of lately. So yeah, if anyone's got any questions.
I think it's probably going to be hard given what you've said, but let's see if there are any. Mr. Maag?
No, thank you.
Mr. Fulton?
Yeah, no questions, thank you.
Ms. Gibb?
No, thank you.
Mr. Cooney?
No, thanks, thank you.
No, and I don't have any either. Thank you, Ms. Feathers. Thank you very much.
Thank you for your time.
Thank you. Our next submitters are, I'm going to refer to them as the Libra family, and I hope I pronounced their name correctly. If I haven't, I'm sure you'll tell me. I saw they were here earlier, but now I'm, oh, there we go. Mr. Libra, your microphone's turned off. You need to activate the sound, please. There we go.
Can you hear me now?
Yes, we can, thank you.
Yes.
Yes.
Just when you're ready.
Yep, I'm ready. Yeah, I am Mel Libre. I am representing my wife and my son and myself as co-owners of the property in 60 U Melody Lane, Tamahere. That is part of the Waikato District Council. There are two items that we would like to raise. The first one is in relation to Rule 22.3.2, and that is we would like to retain Rule 22.3.2 P1 and do not include reference to dependent persons in the rule, and to delete Rule 22.3.2 P1BI that requires the minor dwelling to be within 20 meters of the main dwelling. That's the first issue. And the second will be in relation to the map 27.1. For the first one, Rule 22.3.2, there is no need to stipulate that the dependent persons live in a minor dwelling. The requirement for the minor dwelling to be within 20 meters of the main dwelling is unnecessary and takes no account of the topography or other features of the land. There might be a better site on the land farther away. So that's for Rule 22.3.2. Now, in relation to the map 27.1, first is that our property is located near the Cherry Blossoms Festival, where it is held. I am of the understanding that from the corner of Morrinsville Road until the properties before U Melody Lane, the classification has been country living zone, and that the properties opposite U Melody Lane in Matangi Road are likewise classified as country living zone. Our area is cut off from the other rural areas by the expressway. It is our proposition that the sections located in U Melody Lane should be reclassified from rural residential zone to country living zone. In support, we raise 3 points: urbanization, impracticality of farming, and third, health and safety of residents. Urbanization. The area in U Melody Lane should follow suit those of the neighboring areas in the vicinity. The number of houses has increased to more than 10, not counting those in the neighboring sections that we've counted, totaling 28. The reason for this is that Yung Melody Lane is a stone throw away from Hamilton City. Development can simply be stopped. The need for living quarters near Hamilton City is a reality that must be recognized. Secondly, impracticality of farming, commercial farming. Commercial farming is no longer practical in New Melody Lane. No resident is a full-time farmer in the area. Maybe there are those who raise a few cows, chickens, and sheep, but these are for family consumption, if not ornamental. Most residents are hard-working people, either working as professionals, if not entrepreneurs. I know that there are a few vacant sections planted with maize once a year, but these are contracted out for necessity in order for the lot owner to earn enough to pay for the high rates of the district. Thirdly, health and safety of residents. If we put an average of 3 individuals living in a house, and there are 14 in the area, that would be 42, excluding those living in the neighboring sections. We have experienced inconvenience as a result of farming of maize in the area. The dust that comes from the preparation of the farmland, the odor of the fertilizer to enrich the soil, the noise brought about by the machines that cut the grass, prepare the farmland, and deliver the fertilizer. And if anyone among us should consider raising more animals, the resulting odor of animal poo, the flies these attract, and the noise animals create will distract the peace that most homeowners seek. But most importantly, the health and safety of residents must be considered in the current rural residential zone classification of the area. The increased number of residents are affected by the dust, odor, flies, and noise due to the farming. And how about the children who stay most of the day in the nearby Meadows Early Learning Center along Matangi Road? We therefore ask the council to consider reclassifying the area of New Melody Lane from rural residential zone to country living zone for the sake of urbanization, considering the impracticality of farming, and for the health and safety of residents as well as the children attending the school in the area. Thank you and good morning.
Thank you, Mr. Libre. Let's see if there's any questions for you. Ms. Gibb?
No questions from me. Very clear. Thank you for presenting.
Thank you, Ms. Gibb. Mr. Fulton?
Yeah, I think what's being requested here is a zone change, isn't it? So and whether we got that in a jurisdiction in this particular hearing, I'm not sure. But
I think we can accept the submission as it is at the time that it's been made, and we'll just pick it up in due course.
Okay, thank you. I'm happy about that. Thank you.
Thank you. Mr. Marg?
No, nothing from me, thanks.
Mr. Cooney?
I was going to raise the same point as Mr. Fulton about this will probably be looked at again at the zone extents hearing.
Okay, thank you.
Did you make a go on, Mr. Chairman.
No, you carry on.
Did you make a submission on the seeking a zone change?
No, this is just the submissions that we made to 3 of us in the family. That is all.
Okay.
We can follow that up offline. I think I'm just going back through the submission. I think that the submission does seek that, but we can confirm that.
Yeah.
I just have one question, Mr. Libre. Have you seen the You've made your submission in response to the notified version of the proposed plan. Have you seen the Section 42A reports that the council staff have prepared, which is their response to the various submissions that have been made, and in which they have recommended changes to the proposed plan?
I apologize, I haven't read it.
Because if you go online and have a look, you may find that certainly not the issue, because it's not being discussed at this hearing, the rezoning aspect, but the provisions relating to minor dwellings have been altered quite substantially. One of which is to suggest that to propose, that the separation distance be increased from 20 metres to 100 metres.
Oh, thank you very much.
So I suspect that may be a step in the right direction from your point of view.
Yes.
And I'm not sure that the rule as now drafted, if I'm reading it correctly, makes any reference to dependent persons unless that's in the definition. And that may be where the rubber hits the road on that. But your submission's clear, and we can assess that when we consider everything that we've heard during this hearing. Thank you to you and your family for making your submissions, and to you for presenting it to us.
Okay.
Thank you. Which brings us to Mainland Poultry. Mr. McDean.
Good morning.
Good morning.
Apologies, I haven't provided a summary of my evidence.
Let's go. We're not going to growl at everybody individually, and in fact, I think some of the growling might have been unwarranted. So if it has, because there's been so much information, some of it's come in very close to the end. I can assure everybody that we've read the evidence very carefully, but we're not going to growl at individuals one by one, but we have made the general point about going forward, and you acknowledge that. Thank you.
Excellent. Okay, thank you. So my name's Christian McDean. I work for Kinetic Environmental, and who represent Mainland Poultry. Mainland Poultry are the biggest poultry or layer egg supplier in New Zealand, and are currently building a farm in Waikato district, and just looking for more opportunity to expand their North Island operation. In terms of the original submission, as stated in our evidence, we're reasonably happy with most of our staff recommendations, and also the rebuttal evidence provided by Mr. Cleese on the 24th. However, one of the issues we have with Mr. Cleese's rebuttal is we don't understand where a free-range layer poultry farm would now sit if we don't meet the intensive farming rule. It doesn't comply with the permitted activity farming rule, and if our range areas are considered to be extensive enough that the pasture needs to be maintained, i.e. mowed, then we wouldn't meet the requirement of the intensive rule, which is effectively what Mr. Cleese has said. So we don't necessarily have a problem with that, but we don't know where we would then sit. And it would seem to me from reviewing the plan is that we would end up being a non-complying activity under the catch-all rule, which I think we would all agree that puts us in a worse situation than a restricted discretionary activity.
That's my reading. I mean, we don't normally get into a round the houses discussion, but is that correct? Is that your intention, Mr. Cleese, or is there another pathway that we're not aware of?
Certainly not the intention. No. So my understanding of the rules that we've written is that if the farm isn't intensive, so it's outdoor chickens and the pasture's being maintained, then it's just the same as any other extensive sheep farm, dairy farm, and they're simply permitted under the P1 farming rule. So if you're not intensive, then you're simply farming and you're simply permitted.
I think the issue there is that the permitted farming definition clearly states that we need to be using the in situ soil. and I would argue that, I would suggest that's probably permitted activity, fantastic, but I just don't think we apply, given we have some fairly significant sheds on the site. We bring all of our food in, it's imported feed supply. The birds get virtually no, I know I'm making an argument against why we should be permitted, which sounds crazy, but we bring in all our food, and the birds get very little, if any, nutritional value from the soil itself. So I guess I've had this discussion with council previously, and I don't want to get caught in a situation where we end up being non-compliant.
Yeah, I don't want to get into a debate between you and council staff. I think Mr. Cleese's response is helpful from our point of view, is that he said that it would appear to be a drafting issue, and that the intent is not to do what you're concerned about, which is make you non-complying. So that's a matter that the staff can pick up in their closing.
Okay. So in that respect,
so thank you.
Yes. So from our point of view, we would be happy with a draft, a redraft of the intensive farming rule, where we potentially are picked up by that, or that the permitted activity rule be amended.
I think some of the other poultry interests are suggesting the opposite, in that they're saying they're not intensive farming. They just happen to have chickens that, that live inside but free range around the property, and there's nothing intensive about it.
Yeah, I think you'll hear from Dr. Forrett about that tomorrow.
So I think I suspect we will.
Yeah, and I think, just I suppose for your own benefit, I work in broiler and layer farming operations and have done for a very long time. And I think what you would consider to be an intensive farm with 40-odd thousand birds in a reasonably small space with a reasonably small range area, they still have to mow those range areas, even though they're a lot smaller than a layer farm. So again, a broiler farm, which does have 250,000 birds in it, wouldn't be considered an intensive farm if they were mowing the range.
Yep, understood. Let's move on.
That's it for me.
Very good. Oh, we've moved on faster than I even anticipated. How good is that?
Effectively, it was just a question, really.
That's fine, and that's helpful. And I think you've we're live to the issue. Mr. Cleese is live to the issue, so I think we can leave it at that. Just see if there's any questions from the panel. Mr. Marg?
No, all I see is 2213 being sorted out. So good luck with that.
Mr. Cooney?
Yeah, just touching on that point, the concern you've got is that on the free range outdoor areas, you can have quite an extensive area with chooks running around and all that, but the pasture still grows.
Yes.
That's the issue.
The issue is, I guess it's a bird health issue, is that when the grass gets too long, the birds peck and scratch in it, and they can end up eating some of it, and the longer grass can get stuck in their crop and they die. So, because they don't eat the grass as such, they more peck at the soil and end up with eating some of the grass. So all their nutritional value, all their nutrition comes from inside the sheds.
Yeah, because one of the tests is it occurs within outdoor enclosures or runs where the stocking density precludes the maintenance of pasture or ground cover. So that occurs. So that test is sort of a bit blurred. But then you say, well, we bring in stuff anyhow to feed them.
That's right.
So it's sort of landing in a bit of a grey area.
Exactly.
Yeah. Okay.
And I think it's a reasonably easy fix.
Yeah. Okay. Thank you.
Ms. Gibb?
No questions, thank you.
Mr. Fulton?
Yeah, Mr. Dean, there's a confusion in many people's minds, isn't it, especially the public who are not closely involved with this, of seeing the word free range and what does actually free range mean. And what I'm hearing from you is if they're outside and running around, people see it as a free range poultry operation, but in actual fact, it's an intensive farming from the effect that it's fed indoors and they're housed indoors overnight and all that sort of stuff. So it's an image thing rather than anything else. Is that true?
I would agree with the first part of your statement. I won't comment on the image statement, but yeah, they are inside during the night time. They're generally locked away. They get all their food, all their water. Everything comes from inside the shed. I would agree that it is an intensive farming operation.
So the fox doesn't
Thank
get
you.
them. Yeah.
Exactly. Yeah.
Thank you. I'll finish.
Have I asked you, Mr. Marg? I've had a. I think I did. I think you started, didn't you, Mr. Fulton? Sorry, that's where I'm up to. No, I don't think he has any either, and I don't have any questions either. Thank you very much, Mr. McDean.
Great. Thank you very much.
Our next submitter is Trip Andrews Surveyors. Mr. Rowe.
Yeah. Good morning.
Morning. It is just good morning. Got 5 more minutes and it'll be good afternoon.
Okay. Yeah, good morning. My name is John Rowe, and I'd like to apologise also for not circulating my evidence. So yeah, sorry about that. So yeah, I'm a licensed cadastral surveyor and director of Trip Andrews Surveyors Limited. We specialise in land transfer subdivisions, both rural and urban subdivisions, however, mainly in the rural and rural residential sector and predominantly in the northern Waikato and Auckland jurisdictions. Overall, Trip Andrews are generally encouraged with a variety of proposed subdivision mechanisms that will allow our clients to either restructure existing titles or free up capital by generating additional titles through environmental enhancement projects. Having said this, and as stated in my original submission, I still have concerns on certain aspects of the subdivision rules and how they might adversely affect the intention of that particular rule, leading to undesirable outcomes. These further concerns are what I wish to summarise today. Starting off with the general subdivision rule, we do not support the increase from 20 hectares to 40 hectares. This significant increase in size for this rule appears unjustified and will adversely affect a number of our clients who planned on using this rule based on the existing 20 hectare limit and the subsequent notified limit. It really has come out of left field. Like other surveying consultancies, so just moving on to prohibited subdivisions, like other surveying consultancies, we strongly oppose the prohibited activity status for the rural subdivision activities listed under section 22.4.1.1 and specifically PR4. Subdividing a rural lot under the general subdivision rule, where the subdivision subject title has been previously amalgamated for the purposes of a transferable lot subdivision, is simply unfair and inconsistent with other exemptions to this rule. This scenario is certainly not double dipping as insinuated by council in their rebuttal evidence, because the net result in terms of final entitlement numbers is exactly the same either way. Furthermore, the perceived benefit from council for donor property selling a transferable title is overstated in my opinion, and in a financial sense is significantly less than having developed that same title in situ. So the relief sought is consistency with the boundary relocation exemption, and that any record or title that has been transferred as a donor title and which originally met the relevant size and age restrictions under the general subdivision rule can be subdivided further in the future as a non-complying activity. I do have a current example of this particular scenario, if that would help.
Yeah, no, that would be helpful, please.
Okay, so yeah, as an example, one of our clients has a 45 hectare title, which was created well before 1997 and could be eligible for further subdivision under the new general subdivision rule. Adjoining this title on the same property is a smaller title that we have recently obtained resource consent for to transfer to another property in the district using the transferable lot subdivision provisions. Because the land within that adjoining donor title will be amalgamated with the larger 45 hectare title to legally release it from the donor property, our client will not be able to subdivide using the general subdivision rule on the 45 hectare title, even though the benefit of selling that transferable title was obtained from a completely separate title under a separate subdivision mechanism and under a previous district plan. We don't consider that fair. Moving on to soils, regarding the development restrictions on high-class soils, I argue that which I'm all for, I argue that the 15% restriction on high-class soils, though, is going to be frustrating and unworkable rule that will achieve very little. In my experience, farmers don't subdivide off the best paddocks or areas that could adversely affect their farming operations. The relief sought here is something that is actually practical and workable, like a maximum area of high-class soils you have for any new title. For example, 4,000 square metres, irrespective of final lot size. Moving on to lot sizes, I find it a little bit concerning that council have opted for the larger title sizes across the proposed subdivision mechanisms with a minimum size of 8,000 square metres. I agree there needs to be a clear distinction between rural zone lots and countryside or village zone lots, but there naturally will be with larger surrounding titles. This minimum size requirement will only result in more grazing paddocks being taken out of farming production. Our farming clients in the Franklin area, where the lot size is currently between 2,500 square metres and 1 hectare for new lots, are really concerned with this minimum lot size. I suggest a 5,000 square metre minimum size limit is more appropriate and aligns with what the current lifestyle block market seeks. Transferable title subdivisions. Council's feedback through their Section 42A reports state that the main reason for removing transferable title subdivisions is because the rule has encouraged growth pressures in unplanned areas of the former Franklin area, which has undermined growth hierarchy. I failed to see how shifting an existing title or development right to another property in the same district is any different to relocating that title on the same property they currently exist, such as utilising the proposed rural hamlet subdivision rule. I also disagree that transferable title subdivisions has been detrimental to the protection of high-class soils. Based on our experience with them, I would argue that the subdivision mechanism has been very important to safeguarding high-class and productive soils and creating large farming units in one singular title. In most cases, the donor title is significantly larger than the receiver title and consists of a much larger actual area of high-class soils. So the relief sought is the retention of transferable title subdivision, which has successfully worked for a number of years and could provide landowners an alternative to, say, the hamlet subdivision. Moving on to hamlet subdivisions, we also have some concerns on how these subdivisions are practically going to work on the varied physical constraints throughout the district. As part of my job, I get to visit a number of rural properties, and being compliant with this rule is going to be very difficult in my opinion. Finding an appropriate location on typical rural property to house a cluster of lots with safe building sites that are 25 metres setback from boundaries, have appropriate road access and avoiding high-class soils is going to restrict most properties from utilising this rule. Some relief needs to be provided with the overzealous protection of high-class soils, or have a discretionary activity status if some of these rules are not met. The boundary relocation rules. My only comments regarding the boundary relocation rule, which is a very important subdivision mechanism in this zone, is to delete the requirements that the proposed small allotment must not be located on high-class soils and that the titles must form of a continuous landholding, and also reduce the minimum eligible lot size from 500 square metres to 2,500 square metres in order to be consistent with the operative Franklin District Plan. It doesn't really make sense that an eligible title description for this rule doesn't match what can currently be generated in the district. As mentioned by previous submitters, rural landowners commonly adjust boundaries with neighbouring properties for various reasons, so it is not always a continuous landholding in the same ownership. Generally speaking, all that changes in these subdivisions is lines on a piece of paper, and the land subject to the boundary change usually continues to be used for the exact same purpose as it did previously. So this rule only needs minimal restrictions in my opinion. My last main concern is in relation to boundary setbacks for new dwellings and non-habitable buildings. The Franklin area currently has 10 metre side yards, Auckland has 12 metres, and Waikato is over double that with 25 metres. I suggested a figure of 12 to 15 metres is more appropriate, which still provides sufficient separation between new houses and boundaries. And just one last comment if I can, following on from the surveying company's presentation this morning, which was great. With the directive coming from central government and also the healthy waters provisions, which is the hot topic for farmers at present, the main alternative for many farmers is going to be planting out the stream edges or steeper topography and pine trees, because there is a significant monetary incentive through the carbon trading schemes. I think most of us would agree that the watercourses throughout the district would be much better in native trees, as shown in the surveying company's presentation. However, there needs to be incentive for rural landowners to do this, and yeah, we think that's very important. So that's all I've got to say. Thank you.
Thank you, Mr. Rowe. See if there's any questions for you. Ms. Gibb?
No, thank you.
Mr. Marg?
No, thanks.
Mr. Fulton?
Just one very short one on the lot sizes, the 8,000 to 1.6 hectares.
Yep.
Do you think that this has got a detrimental effect that some people might consider? Well, if we take off 5,000 square metres, well, that's fine. But if I've got to consider 8 to 1.6, I'm losing quite a bit of land. And it would be, rather than saying a simple thing to do, it does make them consider it a lot more because of that.
Yeah, absolutely. I can think of one recent example where a farmer went to cut off an existing dwelling on his property, and that there's quite a big curtilage area, and it ended up being about 4,500 square metres in size. So if we had, 8,000 square metres is bigger than a rugby field. So if we have to go up to there, it's going to include at least one paddock, which could potentially be used for productive purposes on the farm. So yeah, it's too big in my opinion.
That does make a distinction, though, doesn't it, between 5,000 square metres as a country living zone size.
Yeah.
So if you're going to buy that, the person that's going to buy that sort of land has to understand how they're going to use it, don't they? Because it's a bit more than a mumming area.
Yeah, correct. But look, as we've seen over the last few years, people out there are wanting the smaller lifestyle blocks because they don't have time for maintenance anymore. So we just argue that the land is better used for productive purposes like grazing. Yeah.
Okay, thank you.
Mr. Marg?
Nothing from me, thanks.
Mr. Cooney?
Yeah, Mr. Rowe, you gave an example of a title being created, a smaller title. Was that, how was that title created?
Sorry, what was that example?
I think it's the one that you read out, the 45 hectare one that was.
Oh, sorry, got you.
I think,
okay, so
that's what Mr. Cooney's referring to.
Yeah, so that was a farming property with two titles, very old titles. One was 45 hectares and one was approximately 5 hectares in size. So the 5 hectares, that was generated a long time ago. I'm not so sure how it was created. And that was transferred off the property as a transferable title subdivision. So yeah, that land has to be amalgamated with the bigger adjoining title, or the buddy lot, to be released.
Yeah, okay, I got it. Thank you. Yeah, thank you.
No, and I was going to seek a bit of clarification on that point, and now don't need to, so I don't have any other questions. Thank you, Mr. Rowe.
Thank you.
Our next submitter is the Dilworth Trust Board, Mr. Bloomfield.
Good afternoon, Chair and Commissioners.
Good afternoon.
I had prepared and filed a statement of evidence, and then last Friday I also filed a summary statement of evidence, and I just wanted to check that that's been circulated.
Yes, it has. Well, I've got, yes, I have it here, thank you.
Thank you. So if we take the summary as read, then I can just provide a highlights reel if you
That's
like.
what we're after, thank you.
Excellent. Dilworth's submission, the crux of the submission is about how to recognise and provide for their rural campus in Mangatawhiri. The rural campus is it's a school campus which is used to bring Year 9 students from Dilworth's other urban campuses in Auckland and those boys spend a year at the rural campus boarding there and having their education there as well. And the rural campus provides the standard curriculum as well as it provides other educational and recreational opportunities that you can't get in an urban environment. And the rural campus has been operated since 2011. And prior to that, it was a hotel visitor accommodation activity. So it's been a non-rural site for quite some time now.
So if I could just interrupt, Mr. Bloomfield. Sorry, I don't mean to interrupt your flow, but just to note that I do note that your summary statement refers to Mr. Matthews' evidence for Genesis, and I've previously absented myself from that, given that Mr. Matthews is a business colleague of mine. I'm not going to absent myself from listening to what you're saying. That would be a bit, because your submission covers a whole lot of other points, but I won't be involved in any deliberations or questions relating to the Genesis submission.
Thank you, Chair.
Sorry, I didn't mean to interrupt, but I just wanted to get that on the record before you started.
Certainly. My evidence is not really intended to address their submission in any way, but we'll get to that.
Yeah,
as I was saying, the Dilworth submission, the crux of the issue is how to recognise and provide for the rural campus. The concern or the issue that's been raised is that the rural zone provisions, as notified, didn't appropriately provide for non-rural activities. And the Council's 42A report has addressed that issue in part, and I'll come to that. My evidence or Dilworth submission seeks both a site-specific policy for the rural campus, and that's to be implemented by some specific area provisions that Dilworth have sought as well. The submission point for the specific area provisions has been allocated to a later hearing, while the policy was allocated to this hearing. That makes things slightly complicated, obviously, because they are quite intertwined, as well as the Council's 42A report addresses, I suppose, the principles underlying Dilworth's submission, specifically in terms of how exactly out of zone activities should be provided for, whether it's by scheduling or some alternative mechanism, which is obviously what Dilworth's second submission point is seeking. Well, my evidence essentially just supports the inclusion of a site-specific policy for the rural campus. And I intend to follow this up in the later hearing to support site-specific provisions, unless another mechanism is mooted in the meantime. But what my evidence also responds to is the Council's 42A report in relation to how educational facilities in general should also be provided for in the rural zone. And that's because that was part of the Council's response to the Ministry of Education submission as well, which was seeking that RDA status.
Yeah, I understand.
So Dilworth doesn't necessarily have a submission point on how educational facilities should be provided for, but it is a direct response to Dilworth's submission and the principles underlying that. In my summary statement, I just took the opportunity to reflect on the rebuttal evidence of other planning witnesses for other submitters. That's Horticulture New Zealand and Genesis Energy Limited. Both the planning witnesses for those submitters are concerned with the way in which educational facilities should be provided for in the rural zone, and whether that's by a discretionary activity status as notified or an RDA status as recommended by the Council and supported by myself. I can certainly acknowledge the tensions and the issues that are in play with primary functions of rural zones and other non-rural activities that quite often do locate in those zones. My Dilworth submission is the relief sort of site specific. I don't really intend to belabor the point about how educational facilities should be provided for in the rural zone, because that's not of concern to Dilworth. But I felt that it did reinforce the issue that Dilworth has raised, which is how exactly the rural campus should be provided for, acknowledging that there are concerns or issues rather at a district-wide level in terms of that rural zone. And so that's why I feel that it does reinforce the need for site-specific provisions for the rural campus, which is a very long-established activity in the rural zone.
Have you seen the rebuttal section 42A report? It was released on Thursday or Friday?
I have, yes, and my summary statement responds to that as well.
Yeah, okay.
The rebuttal evidence, I'll turn to that now. The rebuttal evidence, the 42A rebuttal, it acknowledges that scheduling is a useful tool for particular out-of-zone activities. The rebuttal evidence doesn't make a firm recommendation that it should be used as a tool. From my reading, the council's expert is saying that this is a plan-wide discussion, and that perhaps this will be picked up at a later hearing. So it's a little bit difficult to conclude on anything right now, but certainly my opinion is that the rural campus should benefit from site-specific provisions.
I thought there was a proposed, well, there is a proposed permitted activity rule. I know that doesn't address the policy point, but I don't think have you addressed that in your summary statement? Because if you did, I missed it. Because they're saying that maintenance, operation and alterations to Dilworth School is a permitted activity, provided the net floor area doesn't increase, and then there's a pathway through an RD rule if you want to expand.
Yes, thank you, Chair. Yes, paragraphs 3.2 and 3.3 of my summary statement go into that.
I'm sorry, I did miss it, and I apologise.
That's no problem. I acknowledge the council's rebuttal there and seeking to turn their minds to perhaps an alternative mechanism. That permitted activity status has been put forward in the event that scheduling is not taken up by the panel or recommended by the panel. So I think even in I could be putting words in the mouth of Mr. Cleese, but it could be that this is still perhaps a less preferred mechanism as opposed to scheduling, which is what Mr. Cleese is suggesting could be a useful tool as well. In my opinion, the permitted activity status, it's a good step, but it essentially does limit the rural campus to what it is today, and there's a resource consent process to follow for anything in addition to that. And the examples that I've put in paragraph 3 is Dilworth couldn't construct a small toilet block or a caretaker shed or anything else without requiring an RDA resource consent or a DA consent, depending on which status is landed on. That's sort of a summary of the issue, and like I said, to me it doesn't feel as if I've got quite to the final conclusion, but that's because it's the site-specific provisions that I'll ultimately be supporting. But I think the principles of that are quite well highlighted even at this point.
Okay, no, that's helpful. Thank you. Let's see if there's. Sorry, I'm assuming you're now finished.
Thank you, Chair. Yes.
Yeah, thank you. Let's see if there's any questions for you, Ms. Gibb.
No questions. Thank you, Mr. Bloomfield.
Mr. Fulton.
Yeah, no, thank you. And thanks for your summary. I think it was very well put out. I think it's a difficulty we're going to have to deal with. So thank you for your submission. Thank you.
Thank you,
Mr. May.
Yeah, no, I have no questions, but thank you for your summary. It's very thorough. And I guess hearing 25 will be another big part to be considered.
Mr. Cooney.
We'll see what we can do there. Thank you.
Yeah.
Just a quick question, and again, this may have been in your main statement, but nothing particularly hinges on it, so that's why I won't have noted it. But is the trust a requiring authority?
No.
So none of its campus sites are
no, that's correct.
Designations.
Dilworth is essentially a private school, but it funds scholarships for education through private land interests and the like. So it is not in any way public or has requiring authority status.
Yeah. Okay. I understand that. I suppose the sort of the philosophical question is, and I understand the point that you're making that says, you're a particular activity and you need your own bespoke provisions. And I know you've also made some comment about educational facilities in the broad. but that's sort of what you are. How do we balance, in your view, the need for your desire to be site specific versus the, I'll call it precedent for want of a better term, that everybody else that's sort of a bit different from the norm will say, well, we need our own special provisions as well. How would we deal with that in your opinion?
I don't believe that the issues to the rural campus are unique to perhaps the issues that are being raised by other submitters. My understanding just from the 42A report is that there's very few submitters in the same position or seeking other site-specific provisions. But the proposed plan already does this. It already has specific area provisions for a few other activities, which I can't quite remember off the top of my head. I think Huntly Power Station is one, for example. There are
that's in a heavy industrial zone. It's not in that's not in the rural zone.
Okay, I could be wrong with that. I think there's agricultural research centres, for example, I think in the rural zone that also have specific areas. So the Dilworth submission sought specific, what was the term, specific activity provisions, which was following a consistent format and style and everything to that mechanism that already exists. So we certainly weren't trying to differentiate the rural campus from any other similar activity, which also finds itself as being a little bit at odds with the underlying zone.
I guess that's my point. That's the issue as I see it. I mean, there may not be other submitters at the moment that say that, but do you think it's good planning practice to have a whole lot of tailor-made provisions for something that's not that different from a lot of other activities that aren't treated in the same way?
Other than potentially the volume that it adds to a district plan, I don't see any particular consequence of identifying activities where there is, I suppose, a specific conflict at issue. Okay. I don't think that there's a planning issue there.
Okay, no, that's fine. Thank you. Thanks for your evidence, Mr. Bloomfield.
Thank you.
Which I think brings us to the end of our morning session. Yes, it does. And we're fractionally early. Let me just get my full screen view back. Is Mr. Fuller online? Yes, he is. What I'm going to suggest is that we've always said that our scheduling is a little bit flexible. Middlemiss and Buckland are due after lunch, which is nominally 1 o'clock. Given that I anticipate that it may take a fair while to work through Mr. Fuller's submissions and the evidence, would you be ready to go at 10 to 1, Mr. Fuller, instead of 1 o'clock, so that we just have a half-hour break?
He's gone to lunch, Mr. Chair.
No, there he is. And he's got his tie on today.
Was that a suggestion I'm out to lunch?
You said it, not us.
We can start at, well, I'm a little bit...
Well, time is ticking by, but let's leave it at 1 o'clock. Let's leave it at 1 o'clock.
I do have witnesses, Mr. Chair.
We'll resume at 1 o'clock. That's
yes,
okay.
Thank you, Mr. Chair.
All right, well, we'll adjourn until 1 and we'll see everybody there. You'll need to log out of this call and re-log on to the new meeting request for the 1 o'clock start. And if the panel wouldn't mind just waiting for a moment once everybody else is gone. Thank you.